Royal Commission is now in session. Please be seated.
Yes, appearances, please.
May it please, Commissioner, I appear with Ms Marsh this morning.
Thank you. Ms Hogan-Doran?
May it please the Commission, I appear today with Ms Katrina Musgrove for the Commonwealth.
Thank you. And we've another appearance too?
May it please the Commission, my name is Finlay. I appear for Mark Wood.
For Mark Wood. Ms Finlay, I don't know if you have any interest in the witnesses who will be called this morning, who I think are Mr Gladman, Ms Carmody and Ms Kruse?
I don't think so.
All right. Well, can we give Ms Finlay a time estimate?
I think an hour and a half for these three witnesses, but there is a mention of Mr Wood in some of the emails that came through overnight, so perhaps Ms Finlay might have an interest.
Commissioner, I might be able to assist. There has been two supplementary statements for two witnesses this morning. At least one of those includes material that would be relevant to Mr Wood's interests.
Looks as if you're stuck here, Ms Finlay.
Thank you, I will do so.
Thanks. Yes, so you're calling Mr Gladman?
I do, but before I do, can I tender some but not all of the exhibits in the list for today? Those are the exhibits commencing on Exhibit 5806 and ending with Exhibit 5938. That's the exhibits that relate to the first three witnesses of the day, Commissioner.
And Commissioner, could I foreshadow that I understand my friend may need to additionally tender the documents that are related to Exhibit 5810 A, which is the supplementary statement of Ms Kruse, which has only been provided to the Commission overnight, and I believe he has not yet had an opportunity to see the documents that are referred to in that.
Up to you.
Beg your pardon, Commissioner?
You may need to tender other documents, I gather, which I'm just checking this, yeah. The supplementary statement of Ms Kruse.
Yes, there's about, I understand, about 6 additional documents which are referred to in that statement, which we're just waiting on production of them from the Commonwealth.
Oh, you don't actually have them yet?
No.
Okay. All right, so it was 5806 through to 5938, I think. Is that correct?
Yes, Commissioner.
All right. Those documents are admitted and marked with the numbers they bear in the exhibit list. And now, Mr Gladman, will you take an oath or an affirmation?
An affirmation, please.
All right. Would you stand, please?
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Yes, Mr Scott.
Thank you, Commissioner. Mr Gladman, would you please inform the Commission of your full name?
Mark Stanley Gladman.
And you were provided a notice to give information in writing and produce documents from the Commission dated the 6th of January 2023?
That's correct.
And you produced a statement in response to that notice dated the 30th of January 2023?
Yes.
And you've also produced a supplementary statement dated the 26th of February 2023?
I did.
Are the contents of your statements true and correct to the best of your knowledge and belief?
They are.
Thank you. You are currently working as a lawyer, correct?
Retired last week.
Okay. I was reading from your first statement, so
Yes.
that's why it's out of date. But until recently, you were working as a lawyer?
Till last Thursday, yeah.
Okay, thank you. Is this right? In January 2016, you commenced work at the Department of Human Services in the role of Deputy General Counsel, Program Advice and Privacy Branch?
Correct.
You held this role until the 7th of December 2018?
Yes.
And from December 2016 to January 2017, you held the role of Acting General Counsel, Program Advice and Privacy Branch?
Sorry, what's the dates? It was a 4-week period, late December to early January. Was that the... Sorry, could you repeat the question?
From December 2016
Yep.
to January 2017, you held the role of Acting General Counsel, Program Advice and Privacy Branch?
Correct.
For about a period of 4 weeks?
About 4 weeks, yes.
Okay, thank you. And that period included the first couple of weeks of January 2017?
Correct.
Okay, thank you. Now, you've got a reasonably large folder in front of you, Mr Gladman. The documents that I'll be asking you questions about are contained in that folder. They'll also be coming up on the screen.
Sure.
The first document I want to ask you a question about is behind, I think, your tab 22, Exhibit 5828, Doc ID CTH.311.0017.9701.
Yep.
Now, with luck, that should be an email chain from the 6th of January 2017 that you have.
Yep, I've got it.
Thank you. And the email chain commences with an email from Mr Menzies McVeigh to yourself on that date, correct?
Yes, correct.
And it opens with, Mark, Sue Kruse would like us to develop as a top priority next week a paper on the department's current practice of averaging income for the purposes of calculating payments under the Social Security law. See that?
I do.
Thank you. This paper should look at the legislative basis for this practice for each payment and identify the circumstances where it is permissible for the department to assume, in the absence of other evidence, that income over a period has been earned pro rata over the period.
Yes.
Do you now understand? Sorry?
Sorry, yes.
Did you understand then that to be a reference to the use made by the department at that stage of a practice of income averaging ATO data to calculate amounts of income earned by a Social Security recipient in each fortnight?
At that point in time, I had very little understanding or background in the issue of income averaging.
Okay.
I could go further.
Sure, please.
So I didn't have a background in Social Security law, and the first time that I became aware of that there was an issue with income averaging, or the first time I became aware of what we now know as Robodebt was when Mr Menzies McVeigh sent me a request for dot points. He was going to, or had come back from a senior meeting and said there was something hitting the media. Could I provide some dot points on income averaging? So I would have done some investigation, tried to work out, because I didn't know what that was, tried to get some dot points, and then the next time I would have come across it would have been with this request. I don't recall whether, I recall a conversation with him about the request, but I don't recall whether the email came first and then there was a conversation, or the conversation and then the email.
Okay. Would this be right? The dot points, sorry, I will draw that. The dot points that you've just referred to, is that something that's happened before this email?
Yes.
Okay, so by the stage of this email, did you have at least a general sense that a practice of income averaging was being used by the department to calculate Social Security recipients' fortnightly income?
I don't recall exactly the extent of my knowledge. I knew there was something hitting the media, that there were letters going out that people were concerned about. And if I put some dot points together, then I must have drawn them from conversation or Social Security guide or something. So I must have had some knowledge, but I think it was probably a fairly low level. It would have been a very low level of knowledge.
Okay. Well, your response to Mr Menzies McVeigh, he was acting Chief Counsel at that stage, correct?
He was.
The substantive Chief Counsel was Ms Mussolino,
Correct.
who was on leave at the time?
Correct.
Okay. So your response to Mr McVeigh's email was to indicate that you would do as he'd requested?
Yes.
And based on Mr Menzies McVeigh's email, did you understand that effectively the product of the work that had been requested would be a legal advice?
I had not exactly. I'd had a conversation with him. As I said, I'm not sure whether it was before the email or after, and he'd set out the circumstances in which this question was coming up. And he'd said that there'd been a meeting, the media inquiries or the issues that were hitting the media had been raised. He said there had been a conversation with Mr. Britton. I don't recall whether he was at the meeting or it was a telephone conversation. And Mr. Britton had said, get the lawyers to explain how we well, I'm not sure if they used the word income averaging, but explain what we're doing, how we're doing it. So my understanding was, at least in the first instance, it was an explanation of how it is that the department is able to average income.
In the form of an explanation in the form of a legal advice or something else?
I'm having some, I've read in preparing my statement, I've gone back and I saw his request for advice, which talked about preparing a document that could be shared with Ombudsman and other stakeholders. But I don't know how conscious I was at that time that it might have a broader circulation. I probably was thinking of it, at least in the first instance, being in the form of a legal advice.
Okay. But the document that, and we'll get to it shortly, but you've reviewed the draft documents that were prepared in response to this request in preparation for your evidence today.
Correct.
And the form of the document that was prepared in draft was originally in the form of a draft legal advice.
Correct.
Okay. And is that consistent with what you've just said, which you think that you're probably thinking of it, at least in the first instance of it being in the form of a legal advice?
Correct.
Okay. And you've mentioned that you had a limited understanding of the program as at this date, the 6th of January, for the purpose of the work for the preparation of the document in response to this request. Did you subsequently gain a more detailed understanding of the program?
I've gained some more understanding at various points in processes over the last 4 or 5 years. So I recall reading, I would describe myself as an interested observer after I finished acting because I had some involvement in it. So some involvement in this, in advising on the Robodebt. So when the Ombudsman's reports came out.
Can I just focus on the intention of my question, and I apologise if it was imprecise, was the development of your understanding of the program following this request up to the preparation of the first draft advice document. Did you?
My apologies, I thought you were talking about my statement for the Commission.
Sure.
So can you just repeat it so I don't confuse the question?
So following this request from Mr Menzies McVeigh,
Yep.
over the course of the work to prepare the document in response to this request, did you then gain a more detailed understanding of the program?
No, I would not describe having a detailed understanding of the program.
But more detailed compared to what your understanding was at the stage of this receipt of this request?
Yes.
Okay, thank you. Did you have assistance from anybody within the Legal Services Division for the purpose of preparing the document in response to this request?
The document that's described as the averaging advice?
Yes.
Yes.
Who did you get assistance from?
John Barnett.
Okay. And what was the nature of his assistance that he provided?
I initially referred the request to him, and then Mr Barnett did first draft.
Okay.
Do you happen to know where Mr Barnett is now?
I believe he lives in Tasmania
Any more
And-
detail than that?
and retired, but I don't have his residential address or anything like that.
Okay, thank you. Do you know how he could be contacted? We've had a little difficulty.
I may have an old telephone number. I don't know. I could check.
Okay, if you wouldn't mind, that would
Yeah.
help. Thank you.
Now, Mr Gladman, you mentioned at paragraph 21 of your first statement that you have been shown an email which suggests that you attended a meeting with Ms Carmody on the 9th of January 2017.
Correct.
By that stage, that is the 9th of January 2017, what role was Ms Carmody occupying?
Acting Chief Counsel.
The role that Mr Menzies McVeigh had been acting in at the stage of the 6th January 2017 email?
Yes. Okay,
And she'd taken over the role of acting Chief Counsel on the 9th of January?
yes.
Okay, thank you. Now, can I just ask that you be shown, please, what I think is behind your tab 31, Mr Gladman, which is doc ID MGL.0001.001.0010. Okay, that should be Exhibit 5836. Do you have that there, Mr Gladman?
Yes.
Okay. Now, that would seem to be, would you agree, a calendar appointment sent to you from Sue Goff with the subject briefing to occur on the 9th of January 2017, and the time for the appointment is 4:30 a.m.
Yes, that must be incorrect.
Right, okay. So there was no meeting in the Chief Counsel's office at 4:30 a.m. on that date?
No.
Okay. So there was only one meeting on that date?
Yes.
You think at 3:30 p.m. in the afternoon?
I believe so.
Okay.
From my examination of the documents.
Would it be unusual to be meeting with someone in your area at the time at 4:30 in the morning?
Extremely.
Okay.
Commissioner, could I just interject by way of assistance? We'll have that document rechecked. One of the people assisting the Commission from AGS is in Perth, and it may be that the way the document's been produced to the Commission picks up their time frame as opposed to...
All right, thank you for that.
I'm indebted to my learned friend. The next document I will seek to show you, Mr Gladman, should be behind your tab 38, Exhibit 5843, Doc ID CTH.3113.0004.6850. Now, do you agree with me that this is an email chain? So firstly, do you have that document, Mr Gladman?
Yes, I do.
Okay. Now, do you agree with me? This is an email chain that commences on the second page with the email from Mr Menzies McVeigh that we were just discussing before.
Yes.
Okay. And then you inquire of Ms Carmody on the 9th of January at 9:30 a.m. whether she would like to see the draft before it is provided to Sue.
Yes.
Sue being Sue Kruse.
Kruse, yes.
And then Ms Carmody says, yes, please, and let's chat about it once I've had a look. And thanks you. See that, top of that page?
I do.
And then on the first page, the first email on the chain on that page is from yourself at 10:38 a.m. You thank Ms Carmody. You note Mr Barnett is working on this today. You say, I wouldn't expect that we'll have anything for you to look at until tomorrow, but we'll try to get you something as soon as possible.
Yes.
And then her email at 11:04 in the morning that day is in response. Thanks, Mark. I understand this kept you all very busy late last week. Do you see that?
Yes.
Can you assist us from your recollection as to what she meant by those words? I understand this kept you all very busy late last week.
No, I don't recall.
Well, do you recall the work that followed Mr Menzies McVeigh's email on the 6th of January 2017 to implement the request that he made in that email involved a substantial amount of work?
Sorry, could you repeat the question?
Do you recall that the implementing Mr Menzies McVeigh's request in his 6th January 2017 email involved a substantial amount of work?
The board, yes.
Okay. In circumstances where he'd indicated that it was a top priority request?
Yes.
Okay. And then in Ms Carmody's email, she notes that she'd had a handover from Paul being Mr Menzies McVeigh?
Correct.
Okay. But then says, I'd like a briefing from you too, please. Can we chat about it today, perhaps this afternoon if you have some time?
Correct.
Okay. And then there's reference to the time for the meeting later in the chain. The proposal is for 2:30 in the afternoon,
Correct.
but do you think it was at 3:30 instead?
I think so from my examination of the documents. It looks like it might have been pushed back.
Okay. Do you have a recollection of what was discussed at that meeting on the 9th of January with Ms Carmody?
No. I have a recollection of a particular meeting with Ms Carmody, which I think, when I look at the document, is more likely to have occurred on the 10th rather than the 9th, which means I have no recollection in those circumstances of what we discussed on the 9th.
Okay. What makes you think you had a meeting with Ms Carmody? So I'll take it in steps. Do you accept that there was a meeting on the 9th of January 2017 with Ms Carmody?
I have no reason to doubt the documents.
Okay. And, but then you believe that there was a further meeting on the 10th of January 2017?
I believe so.
By which time you'd seen drafts of the averaging advice?
I believe, yes.
Okay. I now want to ask you to be shown, Mr Gladman, document behind your tab 39, which is doc ID CTH.311.3.0004.7075, exhibit 5844. See that? See that, Mr Gladman?
I do.
Okay. Do you agree with me that it refers to an attached draft advice for Ms Carmody's consideration?
Yes.
And then the attachment is behind your tab 40, exhibit 5845, doc ID CTH.311.3.0004.7076. Do you have that?
Yes.
Do you agree with me that that is the draft advice as it, in its then state of development at 3:57 p.m. on the 10th of January 2017?
Yes.
Thank you. Paragraph 3 of that draft,
So can you point me to the tab again? I was still on the covering email.
my apologies, tab 40,
It's tab 40.
yes.
Yes.
I just want to ask you firstly about paragraph 3.
Yes.
See the words, we think there are some reasonable arguments that could be made to support the process involving the use of information received from the ATO.
Yes.
Just want you to mentally note those words, we think there are some reasonable arguments that could be made.
Yes.
I'm going to ask you about those words shortly.
Sure.
Okay. And then paragraph 4 has these words, given the complexity of the legislation and the significance of this issue for the department, it may be prudent to obtain external legal advice on this matter. See that?
Yes.
Now, what I want to do, Mr. Gladman, is ask you about paragraph 24 of your first statement.
Yes. So, yes, I've got the first statement.
Thank you. Now, is that paragraph where you describe what you recall occurred at the meeting with Ms Carmody on the 10th of January 2017?
I believe it would have occurred on the 10th, yes.
Okay. And can you just describe for us what your recollection is of what occurred on that date at that meeting?
My recollection is I'd received the first draft advice from Mr Barnett. I had started a process of sort of editing it, moving things around, trying to make things clearer. And I got to a point where, well, I felt that we were trying to, in the first instance, identify arguments that would support what the department and the government was doing. And I got to a point where I felt that the arguments didn't support a conclusion that there was a reasonable basis based on the material before me.
Didn't support that there was a reasonable basis based on the material before you?
That's correct.
Basis for what?
So at that point in time, I didn't feel that I could reach the conclusion that there were reasonable arguments to support income averaging.
Right.
But I also felt that there was a number of matters that I needed to explore further.
Okay. Just for the non-lawyers in the room and watching this, when a lawyer forms a view that there are not reasonable arguments to support averaging, what does that mean in a practical sense?
That the stronger arguments are that you can't average.
And that, is this right, that if the matter were to be determined by a court, the court would more likely find that you can't, that is, the department couldn't lawfully averaging?
Correct.
Okay, thank you. So I cut you off, I think, Mr Gladman. So you'd formed that view, and what else did you, what other aspects did you turn your mind to?
I had two levels of concern when I was looking at the draft advice. So the position I thought we were trying to reach, at least in the first instance, if we could, was to identify reasonable arguments to support what the department was doing. I had two levels of concerns. One was a factual concern, and one was more of a legal concern about the potential arguments.
What was the factual concern?
We had limited detail on what Robodebt involved, just really those dot points that are in that draft advice. The more I looked at our arguments, the more I started to question whether that was really an accurate description of what the department was trying to achieve in whatever processes it was doing. So I remember being concerned, I remember kept thinking, well, how will this apply to a student, for instance? Because students often work full-time over a summer break and a little bit in other times, and then maybe periods of the year they don't work at all. How would averaging work mathematically? And so I started to question myself anyway. I started to think there must be more to this, because that seems like an obvious problem. People must have addressed this in the design. I also was starting to think or at least identify as an area of investigation whether the implementation and the design of the scheme were in alignment. That is, whether there had been a decision to do something a little bit different, whether there was an error in design or whether there was an error in implementation. I wasn't sure. I wanted to investigate that.
Okay. And you mentioned also a legal concern. Is that the concern you described earlier about there not being strong arguments in support of averaging?
At this stage, I felt that I was in a fact-finding role, and the legal concern was I was aware that there'd been a practice of averaging as a last resort, but I didn't understand what the legal argument is that allows you to average even in a last resort. And so I wanted to understand whether I wanted to look at previous previous AAT decisions, if they'd considered it, if there was previous Department of Social Services legal advice or DHS legal advice, because I thought if it's a long-standing practice, then these questions must have come up before and someone must have considered it. So I wanted to examine that.
What was the basis of your understanding that averaging had been done historically as a last resort?
The Social Security Guide, I think.
Okay. And what did you understand averaging as a last resort to mean?
After inquiries have been made to try to get material and they've exhausted all of their avenues of inquiry.
Inquiries with whom?
The recipients and employers. I'm not sure if they went further. But.
Okay. Did you reach any conclusions as to what recommendation should be made for the purpose of your discussion with Ms Kruse on the 10th of January 2017?
The purpose of my meeting was to make a recommendation to her.
What was the recommendation that you had a purpose of making?
That rather than do an internal advice, we go straight to getting external advice.
And why did you think that should be done?
I thought that a number of reasons. In the first instance, I wanted to put in place a process where we could start to do some of this fact-finding or this investigation that I was referring to. So a process to understand what is it the department was trying to achieve, what was its implementation, what consideration had been given to some kinds of benefits, are they excluded, were they intended to be excluded from this, what advice had been previously given, and what options might there be to effectively re-engineer the processes. So that I thought would involve quite a bit of work. And one of the situations where we would often get external advice is when you just don't have the capacity to, someone in-house hasn't got the time to, say, go offline and just work on that. So that was one reason. So I thought that would put in place essentially a process by which the in-house lawyers could work with the clients and with AGS. They could identify questions, identify background, and there'd be a way of examining issues. And it would probably slow things down a little bit because we've been asked to do it in 2 days. This would sort of allow it to be a little bit more considered. I thought often we get legal advice externally because of expertise, and I thought some of the judgment calls that might be involved in working out to what extent can you use ATO information, how far can you use it, would require some judgment calls, which you would want people who have good background in admin law and government decision making. And the third reason was to provide a level of arm's length consideration or objectivity or something along those lines.
That is arm's length from the department
Yes,
and greater objectivity of the advice
yes.
than if it had been provided in-house.
At the least, it gives people assurance that it's been looked at by, it's been objectively considered because it's been considered by someone external to the department.
That process of fact-finding that you're describing, am I right in understanding your evidence that you had in mind that process to be ongoing after the external lawyers were retained and to be, is that correct?
Correct.
And to be undertaken in consultation with them as they formulated legal issues?
Correct.
Thank you. And did you have in mind a particular firm or legal service provider that would be suitable for this external advice?
I think I suggested AGS, but it could have been anyone. But AGS seemed an appropriate one for me.
Okay, and why is that?
Because of their background and history with advising government.
Okay. And when you say you think you suggested AGS, to whom do you think you suggested?
Can I correct that? I did suggest AGS to Ms Carmody.
Okay, and the concerns you had about the strength of the arguments in favour of the use of averaging that you've described to us today, did you communicate that concern to Ms Carmody?
I did.
How did you communicate it?
In our meeting, I recall saying that John Barnett had prepared a draft, done his best to come up with some arguments. I've had a bit of a look at them, but I think they're weak.
Okay. Next document I want to show you, Mr Gladman, is behind your tab 42, doc ID CTH.3.881.0001.008, which should be Exhibit 5847. Do you have that, Mr Gladman?
I do.
Do you agree with me that's an email chain involving yourself and Ms Carmody on the 10th of January 2017?
Yes, from Ms Carmody to me, yes.
Well, it starts with an email from yourself
Yeah, I apologise, yes.
and says, Lisa, for your consideration. See that?
Yes,
And is this that email at the bottom of the chain?
yes.
If I could call out the email at the bottom of the chain, please, to the operator. From the way it's drafted, do you agree with me that that purports to be a draft email to someone called Leo?
Yes.
Who was Leo?
Leo Hardiman was a senior AGS lawyer.
Right. And what can you describe in general terms the nature of his expertise?
He was in the Officer General Counsel, I believe. Been there for a long time, very senior, advised on lots of different aspects, I think, of government.
Okay. And what was the purpose of this draft advice to him that appears in this email from yourself to Ms Carmody?
I'd forgotten about that email until I was preparing my statement. I'd remembered that I had proposed AGS advice and we were going down that track, but I had forgotten until I saw this email that this email occurred, so I could only really speculate on what I would what I imagine its purpose is.
Well, reading it now,
Yep,
do you agree with me that it purports to be draft instructions to retain Mr Hardiman for the purpose of providing the advice that you'd recommended be obtained from AGS?
yes,
Thank you. And then Ms Carmody's email and response identifies two things, though, before we instruct AGS. One is we need to make sure the relevant area in the department wants legal advice, Scott
Correct.
Britton's area. And then secondly, we need to be clear about whether advice has already been sought from LSD about any of these issues.
correct.
Do you have any knowledge about whether any inquiries were made with Mr Britton's area about whether or not they wanted legal advice?
I don't believe, I made no inquiries,
Okay, are you aware of any inquiries being made?
no. I'm sorry, I'm not aware of any inquiries were made
With Mr Britton's area?
with Mr Britton's area.
You're aware of the reasons why those inquiries were not made?
I don't recall. I could only, I think that it would have been me that didn't make those inquiries, and I could only now speculate as to what I think the reason would have been based on the way I operate and the way I was thinking at the time.
Well, I won't ask you to speculate, but I will ask you to identify any of the surrounding circumstances that might inform an answer to that question as to why inquiries were not made with Mr Britton's area. Can you identify what those circumstances might be?
In my meeting which I believe was on the 10th with Ms Carmody, where I recommended that we go straight to get AGS advice, she said, I'll go and speak to Sue about it, being Sue Kruse. So I believed that she was going to take up the issue, and I believed that she was going to be supportive, that is, Ms Carmody was going to be supportive in advocating that. And because Ms Kruse was acting Deputy Secretary and Mr Britton was a band one in the way that the department operated, I thought her views would prevail over his. So his views would be not particularly relevant.
Okay. Do you have any knowledge of any circumstances that might indicate that his views would be contrary to getting legal advice?
No.
Okay. And then as to the second question, whether advice has already been sought from LSD about any of these issues, are you aware of any inquiries that were made by yourself or others as to whether any such advice had already been sought from the Legal Services Division?
Yes.
Okay, and what can you assist us in that respect?
I asked Mr Barnett right at the start whether we'd advised on it, or I'm not sure if I asked, but it certainly came up in a conversation that he indicated that we hadn't advised on it. And in examining the documents that were made available to me, I could see that I asked the FOI and litigation branch whether they had advised. But until seeing those documents, I'd forgotten that I'd asked the FOI and litigation branch that.
Did they produce any indication that they had?
I got a response from Mark Hester, which had a description of some commentary on some AAT matters.
But beyond that?
He said that's all, that was the extent of their advice.
Right. And by way of commentary, may we take it that it's not an advice directed specifically to the question of the lawfulness of averaging?
Not in the form of a legal advice. From memory, it indicated that there were some AOT cases that had been critical of averaging and some that had actually used averaging.
Okay. The next document I want to show you, Mr Gladman, is behind your tab 43, I think. Doc ID CTH.3881.0001.0009, Exhibit 5848. Now, you agree with me, sorry, firstly, do you have that email, Mr.?
I do.
Do you agree with me that the first, that's a chain of emails starting with the email from yourself on the 10th of January containing the draft email to Mr. Hardiman?
Yes.
But then a separate email in response from Ms. Carmody saying, Leo just returned my call, so I've had a preliminary discussion. He would be able to do the work, i.e. he has capacity and experience. We now need to determine what work needs to be done.
Yes.
And did you understand from that email that Mr. Hardiman was able to do the work on the AGS advice that you'd recommended be prepared?
That's how I would have interpreted it.
Okay, and were draft instructions to AGS prepared?
Draft instructions, I think, were already in train.
Ah, I see. When did work on the draft instructions to AGS commence?
I'm not entirely sure. I believe I would have asked Mr. Barnett to start preparing it as soon as I thought. I don't know. It could have been. I'm not sure. I believe I would have asked him, but I don't know if it was after my meeting with Ms. Carmody on the 10th or when it was. I'd have to look at the time frames, like when he sent it to me, to try to line it up.
Okay. Can I ask you to have a look, please, behind your tab 45, Mr. Gladman? Doc ID CTH.38881.001.0025, Exhibit 5850, and also behind your tab 46, CTH.3881001.026, Exhibit 5851. Do you have that?
I have. Just to make sure got the same documents. I've got a document that says, Lisa, here's the background for AGS advice.
That's an email dated the 10th of January 2017 from yourself to Ms. Carmody.
Yes.
Okay.
And then there's a document with a typo in the heading of instructions to Australian Government Solicitor.
Thank you. And noting the typographical error, are they the draft instructions to AGS as they stood at 10 January 2017 at 5:27 p.m?
I believe they would be the beginning of some material for AGS.
Okay. How much more work would have been needed to prepare instructions to AGS based on your experience? That is, work following the draft up to this point in time.
I think it depends how people want to approach it, but we could have started with a very brief email to AGS and some initial telephone conferences, for instance, and then starting to put material together. It didn't have to be complete and comprehensive right at the start, I wouldn't have thought.
Okay. Well, subject to proofreading and correcting typographical errors, as at the date of this email that attached these draft instructions, how quickly could instructions have been conveyed to the AGS following this email to retain them?
Very quickly. Well, I think we could have sent over the one that I typed up that said, Dear Leo, the one that was about a paragraph. We could have started with that because that indicated that further material would follow.
I see. And then how long would the further material normally take to develop based on your experience?
Some of this sort of legal material could go over, or the references to legislative provisions could go over pretty quickly. The material with clients, like drawing together descriptions of what they were doing, what was approved, what was implemented, would be a little bit dependent on who's around in the client area and what information we could get. But we could do it iteratively, I would have thought.
Okay. Can you give us a ballpark whether it might take weeks, months?
Not months, certainly. I mean, I would have thought the initial email to Leo that I drafted and this sort of stuff, could have gone over that in the next few days, and maybe over the next, I don't know, week, depending on who's around.
Okay. That can be taken down. Just going to ask you about paragraph 42 of your first statement, Mr. Gladman.
I've got it.
You state you believe there was a meeting between Ms Carmody and Ms Kruse to discuss obtaining AGS advice.
That's what it says in that statement. I corrected it in my supplementary statement.
Yes. And what was the correction to that paragraph, just for the for all of us to hear now?
I assumed Ms Carmody had come into the office I was occupying and said she was on the way to meet with Ms Kruse. Because we had previously been working on getting AGS advice and I'd previously recommended it, and she said she was going to speak to Ms Kruse, I assumed that the purpose of that meeting was to put to her that we get AGS advice. After I filed my statement and I was going over in my head that meeting, I couldn't recall her specifically saying she was going to raise the AGS advice. I thought potentially it was an assumption on my part because of the previous, because of the circumstances around it.
Sure. Did she tell you anything about the subject of the meeting she was going to have with Ms Kruse?
No, it was very brief. She came into the office I was using, left a document, said for your info or something like that. I'm off to have a meeting with Sue Kruse.
The documents that she left with you, sorry, I'm just trying to bring it up, Mr. Gladman. Are those the documents that you refer to at paragraph 9 of your supplementary statement?
Yes.
All right.
A document. It was a single document.
I see. In what form was that document provided to you?
Hard copy.
Was it in an envelope or was it?
Just a bit of, like a printout.
Right.
Look, from memory, it was in the form of like a printed email.
Okay.
But one that hadn't been sent. So, you got a draft and you press print.
Did you look at what the document was?
After she left.
Can the witness please be shown exhibit, this should be behind your tab 103, Mr.
103?
Gladman. Exhibit 3802, doc ID CTH.0028.0002.0016. Do you see that?
Yes.
Is that the document Miss Carmody gave you on her way to her meeting with Miss Kruse?
I think so.
Okay.
I can't say it's exactly the same form, but it accords with what I remember.
I see. Do you have a recollection of when this exchange with Miss Carmody happened?
Not the exact day.
Was it after the 10th of January 2017?
Yes.
Miss Carmody ceased acting as Chief Counsel on the 16th of January 2017, correct?
I'm not sure.
Okay. Do you have a recollection as to when Ms Mussolino came back from leave?
No, only when I started to get emails from her.
Okay. Do you have a recollection at all at the proximity in time of this exchange with Ms Carmody in proximity in time to the meeting you had with her on the 10th of January 2017?
I think it was within a few days of that, but I don't know the day.
Okay. Commissioner, that's the evidence of the witness.
Ms Hogan-Doran?
Nothing arising, thank you, Commissioner.
Okay, thank you. And I won't ask you, Ms Finlay. You want Mr Gladman excused?
Yes, please, Commissioner.
Thanks, Mr Gladman.
Thank you very much.
Excused. And if you can find that phone number, would you let somebody at the Commission have it? That's for Mr
Absolutely.
Barnett. Thank you.
Commissioner, I call Lisa Carmody.
Commissioner, just while the witness is attending, I'm instructed that a hard copy of the material that's referred to in Ms Kruse's supplementary statement has been made available to counsel assisting.
I believe it might be on the bar table, but I haven't yet had the opportunity to read it.
All right, you might manage it at morning tea, I suppose.
Yes.
Ms Carmody, before you get comfortable, would you prefer an oath or an affirmation?
An oath, please.
Thank you. If you'd stand, we'll have that administered.
Your response is I do. Please place your right hand on the Bible. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Commissioner. Ms Carmody, could you please inform us your full name? Take your time. I don't want to rush
Sorry,
you.
let me just reattach. Thank you. Lisa Marie Carmody.
Thank you. Were you provided a notice from the Commission to give a statement and produce documents dated the 10th of February 2023? It might assist, Ms Carmody, there's two folders in front of you.
Yes.
The large folder is, in general, documents that I'm going to take you to. I understand the smaller folder might have your statement and your notice,
Thank
at
you.
least your statement, which refers to your notice in paragraph 1.
Thank you. Yes, so I received the notice in its final form on the 13th, and I received the draft, I believe, on the 9th or 10th.
My question was the date of the notice, which you'll see on the 5th page of the notice.
Sorry, did you say the 5th page? Yes, the 10th of February.
Thank you.
Thank you.
And you produced a statement in response to that notice dated the 23rd of February 2023?
I did.
And the contents of your statement, are they true and correct to the best of your knowledge and belief?
Yes, they are.
Thank you. My questions today, Ms Carmody, will relate to a period from the 6th of January 2017 up to the 16th of January 2017. What was your employment role during that period?
So my substantive role was General Counsel Commercial Law, so on the 6th that would have been my role. I commenced acting in the role of Chief Counsel for the Legal Services Division on Monday the 9th of January 2017, and I did so until Sunday the 16th.
Just looking at your statement, paragraph 11 on page 6.
Yes. Sorry, apologies. Sunday was the 15th of January.
Yes. And so did you cease acting then?
I did.
Okay. And you returned to your substantive role then, correct?
I did.
Okay, thank you. Now, the first document I want to ask you about should be behind your tab 22.
Yes.
Be doc ID CTH.311.0017.9701, exhibit 5828.
Yes, I've got it.
You have that?
Yes.
Now, do you agree with me that's an email chain starting with an email from Mr Menzies McVeigh on the 6th of January 2017,
Yes, I agree.
who was then acting Chief Counsel for the department?
Yes.
Contains a request that stated to originate from Sue Kruse for a paper on the department's current practice of averaging income. You see that?
Yes, I do.
There's a response at the top of that chain from Mr Gladman, also of that date, 6th of January 2017.
Yes.
CC to yourself.
Yes.
Obviously, you weren't acting Chief Counsel at that stage. Can you assist us why you might have been CC'd to that email?
I expect that Mr Menzies McVeigh copied me in knowing that I would be the acting Chief Counsel from Monday the 9th.
Right,
So for my information.
right. What you were coming into the next Monday.
Correct.
Okay. Next, going to take you to your tab 8, Ms Carmody. Doc ID CTH.3135.0001.0004.58, sorry, exhibit 5814, I think.
Yes.
Okay. Now, do you have a appointment in Paul's office involving yourself on the 9th of January 2017 for a handover?
Yes, that's what the document is.
Okay, and can you assist us as to what that meeting involved?
So the handover meeting will have been to give me an update on matters that Mr Menzies McVeigh thought I should be aware of for the upcoming week. I don't have a very detailed recollection of the meeting itself, but I do have a recollection of speaking to Mr Menzies McVeigh when I commenced in the role that week.
Okay, and was there any discussion about the matter covered in his email on the 6th of January 2017 that we've just discussed?
There will have been a discussion about the matter, but I don't remember the particulars in terms of the elements of the matter or anything like that.
Okay. The next document I want to show you, Ms Carmody, is behind your tab 38, exhibit 5843, I believe, doc ID CTH.3113.0004.6850.
Yes, I have that.
Now, that, do you agree with me, is an email chain commencing with Mr Menzies McVeigh on the 6th of January 2017 that we've just discussed.
Yes.
And as the chain proceeds, do you agree with me that the upshot of it is that you refer in an email to Mr Gladman about the subject of Mr Menzies McVeigh's email to the handover you had from Mr Menzies McVeigh, but you request also a briefing from him as well?
Yes, I agree with that.
Thank you. And do you have a recollection that briefing did occur that day at 3:30 p.m?
I have a recollection of having a meeting, probably multiple discussions with Mr Gladman that day. My review of my diary from that period showed that the meeting had been scheduled at 3:30 p.m, notwithstanding that this said 2:30. And I do remember speaking to Mr Gladman, yes.
Okay. Do you have a recollection of what was said in your discussion with Mr Gladman in that meeting?
I have a recollection of a discussion in relation to that email and generally what was ahead for us that week. I don't have a recollection of particular elements of that discussion, what specifically we discussed.
The next document I want to show you, Ms Carmody, is behind your tab 39, doc ID CTH.3.113.0004.7075. Do you have that?
Yes.
And also, if you could turn up your tab 40, Exhibit 5845, doc ID CTH.3.113.0004.7076.
Yes, I have that.
Now, do you agree with me? The second document I just identified is the attachment to the first being an email from Mr Gladman to yourself on 10 January 2017?
Yes.
Thank you. And that attachment was a draft advice dealing with the matter that had been requested by Mr Menzies McVeigh in his 6 January 2017 email.
Yes.
In particular, dealing with the question of averaging as it was then used in the Robodebt scheme.
It was a draft advice dealing with some of the matters raised in the email from Mr Menzies McVeigh. It contained some budget, some information about the process as we knew it, and some discussion that I think perhaps in a later iteration referred to averaging.
Well, if you look at the question point 2 on page 1, you've sought advice on whether it is open to the department to rely on information received from the ATO about annual income amounts to calculate a customer's entitlement to income support, and whether the department should use its information gathering powers to obtain detailed information about when income has been earned, i.e. by compelling detailed information from an employer rather than relying upon averaging. See that?
Yes.
And paragraph 3 says, we think there are some reasonable arguments that could be made to support the process involving the use of information received from the ATO about annual income amounts to calculate a customer's entitlement. Do you see that?
I do.
And then paragraph 4 contains a recommendation to get external legal advice on this matter.
I see that.
So do you agree with me that this is a draft advice dealing with the lawfulness of averaging?
Yes, with an emphasis on draft advice.
Yes.
Yep.
Do you have a recollection of having a discussion with Mr Gladman on 10 January 2017, during which he expressed to you his view that the arguments in support of the use of averaging were weak.
I'm not sure that I have a recollection as specific as that, but I do have recollections of having discussions with Mr. Gladman over that period of time, and that would have included the 10th.
Right.
Yeah.
So do you have any recollection at all of Mr. Gladman expressing a view to you during this period from the 9th of January until you ceased acting on the 15th of January as to the strength of the arguments that could be made in support of the use of averaging?
My recollection is that we were at the time trying to identify, first trying to determine the details of the process, what it was that was underway, and that was particularly relevant for me as someone coming into that role with a commercial rather than a social security background. And I believe that it wasn't immediately apparent to us that there was clear legal advice supporting the process at that time. I don't have a specific recollection of Mr. Gladman saying the arguments were weak, but from my review of the correspondence that week and my review of the draft advice, it is apparent to me that we weren't expressing it in terms that it was strong.
And in reference to what you've just said, can I just direct you again back to paragraph 3 of the draft that we've been discussing?
Yep.
We think that there are some reasonable arguments that could be made to support the process. Now, can you assist the non-lawyers in this room and those watching what a lawyer means when they say we think there are some reasonable arguments that could be made to support the process?
Well, I'll preface it again, if it's okay, by pointing out that we're in the position that we were preparing a draft response, and I had understood from the tenor of discussions that week that this process that we were looking at that week is one that had been underway for a period of time and had not changed significantly, that it was more about scale than anything else. And so the reference, my recollection is that was based in part on our understanding that this is something that had been done and that there was some relevant legal advice that may have gone in part to what the department had been doing over a period of time.
I'm just asking you, Ms. Carmody, to translate into lay terms what the phrase "we think there are some reasonable arguments that could be made to support the process" mean.
That there may be a basis to support the process.
Isn't it a familiar phrase that's often used by lawyers where they're seeking to indicate that there may be some arguments to support the proposition, but the arguments are not strong?
I would agree that it indicates that there may be counter-arguments, yes. Yes, I would agree with the way you've put it.
Thank you. So, have a recollection that at the meeting with Mr Gladman on the 10th of January 2017, you recommended that advice be obtained from AGS?
I don't have a specific recollection of that, but given I know that we had contacted AGS, I don't dispute that version of events.
And by contacted AGS, who contacted AGS?
From my review of the records, I've determined that I contacted AGS, and I can see that through the correspondence that I sent to Mr Gladman in relation to that.
And by correspondence you sent to Mr Gladman, are you referring to the document behind your tab 43, doc ID CTH.3.881.0001.0009,
Yes,
exhibit 5848,
yes,
where you, in response to a draft email to someone called Leo, you say, Leo just returned my call, so I've had a preliminary discussion. He would be able to do the work. He has capacity and experience. We now need to determine what work needs to be done.
yes,
Okay, and Leo being Leo Hardiman
yes.
of AGS. Okay. Can I ask you to look then at another document behind your tab 42, doc ID CTH.3881.0001.0008, which should be exhibit 5847.
Yes,
You have that?
I do.
And again, that's another email from you in response to Ms Gladman's draft correspondence to Mr Hardiman. Do you agree with me on that?
Yes,
In which you identify two things that need to be done before AGS is instructed. Do you see that?
I do.
One is you state we'll need to make sure the relevant area in the department wants legal advice. See that?
I do.
You refer to Scott Britton's area.
Yes.
Do you have a recollection of whether you or anyone else, to your knowledge, made inquiries with Scott Britton's area about whether they wanted legal advice?
I don't have a recollection of me doing so. It is possible that Mr Gladman or someone in his branch did.
Okay. And that you also state we need to be clear about whether advice has already been sought from LSD about any of these issues,
Correct.
LSD being the Legal Services Division.
Yes.
Do you know whether or not inquiries were made to ascertain whether such advice had already been sought in the past?
It is my belief that inquiries were being made, and just to give some context around that, as we were having discussions throughout that week, I was asking questions about what other advice might exist, in part because that might be useful to me to see what has already been provided internally or externally. And my sense was that people were reviewing what existed.
Did you at any stage identify any advice obtained previous to this email from LSD about the lawfulness of averaging?
No, I don't believe I did in that week.
Okay, thank you. Do you have a recollection that during the meeting on 10 January 2017 with Mr Gladman, you told him that you would speak to Miss Kruse?
I don't have a recollection of that.
Do you have a recollection that after this the meeting on 10 January 2017, you went to see Miss Kruse?
I don't have a recollection of that.
And do you have a recollection? I'll just ask you be shown what's behind your tab 103, Miss Carmody, Exhibit 3802, Doc ID CTH.0028.0002.0016.
Yes, I have that.
It's Exhibit 3802. Do you have a recollection of providing this document at any stage to Mr. Gladman?
My understanding is that this document in a slightly different form, I emailed to Mr. Gladman and Mr. Brazel for their thoughts. And it is possible, although I don't have a specific recollection of it, that I have printed this version and provided it to Mr. Gladman, but I cannot recall.
Okay. Well, the other version of it that you say you provided to Mr. Gladman and Mr. Brazel for their thoughts, is that the document behind your tab 101, Doc ID CTH.3068.0011.4126, Exhibit 5901?
Yes, it is.
Thank you. Now, you're aware, aren't you, that draft instructions to AGS were prepared?
Yes.
And if I could ask you then please to look at your tab 45, Doc ID CTH.3881.0001.0025, Exhibit 5850.
Sorry, could you repeat which tab?
45. And also, if you could go to your tab 46, Exhibit 5851, Doc ID CTH.3881.0001.0026.
Yes, I have those.
Okay. Now, do you agree with me that the first document I identified is an email from Mr. Gladman to yourself, dated the 10th of January 2017 at 5:27 p.m,
Yes.
and that the attachment to that email is the second document I identified to you, which is draft instructions to the Australian Government Solicitor?
Yes.
Okay. And do you have a general recollection that at about this time, draft instructions to AGS had reached this stage of preparation? That is, at this level of detail?
Yes, I have a general recollection of that.
Okay. And do you have experience in the process for briefing the Australian Government Solicitor?
Yes, I have briefed lawyers from the Australian Government Solicitor before.
Okay. And based on that experience, can you assist us as to how long it would take to further develop these instructions before they're in a position to be provided to AGS for the purpose of retaining them?
My view is that it certainly would have taken longer. They weren't in their current form ready to be provided to an external legal advisor. In terms of the length, my view, based on my general recollection and my review of the correspondence, is that there were a few moving parts, and these draft instructions, I think, came in part out of the email from Mr. Menzies McVeigh sent on the 6th, as did the averaging advice. In addition, review of the extent to which there was other legal advice that might relate, even if not entirely on point, was underway. So these, you know, to my mind, I don't know. I think your original question was whether I have a view about how much longer it would take. I don't have a view, but I think it would be beyond the time that I was in the role.
Sure. I'm not putting to you that it was in a position to be put at a particular point in time. I'm just seeking to ascertain, based on your experience, how long would it usually take to take what is these draft instructions to the AGS to be finalised, and to an extent that it was possible then to retain the Australian Government Solicitor?
I think it would, I'm not trying to be difficult at all, but I think it would depend on the circumstances. So, for instance, there could be discussions that might be had, further instructions from the business area in the organisation, potentially further conversations with representatives from the Australian Government Solicitor. So I think it depends on the complexity of the matter. When I have reviewed these in preparation for this, they still appear to me to be very much in draft, but it could have taken a couple of days or a couple of weeks to bring them together.
Okay. Yeah. So a couple of days, a couple of weeks.
Correct.
Another way of doing it might have been to send the email to Mr Hardiman that Mr Gladman had drafted with further briefing material provided iteratively by the department over the following weeks. Can you comment on that?
Well, my review of that email from Mr Gladman to me was that it was for me to use as an introductory email, and I can see from the timing of the email from Mr Gladman to myself and the various responses that I had already reached out to Mr Hardiman and had a conversation with him. So there didn't seem to me to be a need to send that particular email at that time when I review it.
Okay.
Yeah.
Well, perhaps the way I might put it is this. Have you got experience in retaining the Australian Government Solicitor where the initial retainer is communicated by a relatively general retainer letter, followed by further more detailed instructions provided iteratively over the course of the retainer?
Yes.
Okay, thank you. Can I then ask you please to go to your tab 102, Ms Carmody, which is doc ID CTH.3754.0001.0001, exhibit 5902.
Yes.
Now, do you agree with me that this is, in effect, a more circumscribed version of what had appeared in the draft advice that we've been discussing?
It is a different version with some information, I believe, was in the advice referred to as the averaging advice, and some additional information, I believe, that was not in that advice.
Sure. So there's some further development from the document that I showed you earlier, but many of the matters identified in that document have made their way into this document.
Yes.
Okay. Now, it says at the top, there's some words in red at the top.
Yes.
The first set of words at the top in red are draft only.
Yes.
So may we take it that this was never provided in final?
Not to my knowledge.
Okay. But then the next words are hard copy delivered to Sue Kruse, 13 January 2017. Do you see that?
I do.
And paragraph 44 of your statement, you indicate that this seems to indicate that you did provide this document to Ms Kruse on the 13th of January 2017, correct?
So in my statement, I refer to this piece of correspondence restating what is in there, that the hard copy was delivered to Sue Kruse on that date, yes.
Yes, and paragraph 44 of your statement, which is on the screen, describes these words in red as having been added by you.
Yes,
Okay. As a record of you having in fact provided it to Ms Kruse on that date.
yes, that's my belief.
Okay. That is, your belief is you did provide it to Ms Kruse on that date.
My belief is that I added that note as a record to myself that it was provided.
Okay. And do you have a recollection of providing it to Ms Kruse on that date?
I don't have an independent recollection of that, no.
Well, is your note right?
Pardon?
Is your note right? What are you saying?
I believe my note to be correct, Commissioner, yes. I can't picture myself in the location where I can say with certainty that I recall handing it to Ms Kruse or to anyone in her office.
Right. Can I just ask you about the words that start underneath the introductory word Sue?
Yes.
That is, I realised that to some extent circumstances have moved beyond this.
Yes.
Can you assist us as to what might be the circumstances that have moved beyond this note?
Through this process, obviously, I've reviewed the email correspondence that I was engaged in that week and the sequencing of events that took place. And I've looked at this statement with reference to that. My opinion is that I was referring to likely the variety of pieces of correspondence that I had sent to Ms Kruse, coupled with the formal notification received that week of the Ombudsman's own motion investigation, which we had received informal notification of the week prior, but formal notification of that week. And I believe that that notification will have potentially pivoted some of the sort of matters that we were dealing with that week so that they were more specifically focused on the notification of the own motion investigation.
Can you elaborate on that, please, Ms Carmody?
So if the own motion investigation involved consideration of the legislative basis, for instance, but the note from Paul Menzies-McVeigh had referred in the broad to that, but had also referred to having a position in place earlier that week. My belief is that we will have paused, in effect, to redetermine what work needed to be done to focus on that investigation. And I think that that reference is a reference to a kind of moving feast, as it were, of priorities that week.
Do you have a recollection of receiving any instructions from Sue Kruse to that effect?
To the effect of reprioritising, do you mean? No, I do not.
So I'm not meaning to be critical, but is this right? You're speculating as to what those words are. I realise that to some extent circumstances have moved beyond this.
I am speculating, yep.
But you were aware, do you have a recollection of being aware that on the 10th of January 2017, the Ombudsman formally notified of his intention to undertake the investigation that you've referred to?
I do have a recollection, although I'm not sure that I was aware on the 10th, which I believe was a Tuesday. I was made aware early that week of the intention, and there was some media around it, and that may, if that was the 10th, then yes.
Okay. Can I just direct you back to Mr Menzies McVeigh's email that is behind your tab 22, doc ID CTH.311.0017.9701, exhibit 5828. And as you've acknowledged, you were CC'd to this email on the 6th of January 2017.
Yes.
And I'm just going to ask you about the words just above the sentence. Let me know if you have any questions about this. And those words are: the advice should include an executive summary for use by senior executives and detailed references to statutory provisions for use by stakeholders such as the Ombudsman's Office.
Yes.
Doesn't that suggest that the purpose of this advice was to assist the department in responding to the Ombudsman's investigation?
To me, it suggests that they would be a stakeholder, but whether it was directly for that purpose, can be inferred. But I'm not sure that it was. I'm not sure of the extent to which that was in my mind at that time.
Well, do you agree with me that, given the stated purpose in this passage called out of the proposed advice, included detailed reference to statutory provisions for use by stakeholders such as the Ombudsman's Office, putting the work on the advice on hold by reason of the formal notification of the Ombudsman's investigation would seem to be inconsistent with that purpose?
I don't know that I recall it being on hold. I just recall attention being sort of moving between a range of issues over the course of that week.
Do you have a recollection of, at any stage prior to ceasing acting as Chief Counsel, communicating to Ms Kruse that the Legal Services Division recommended that external advice from AGS be sought?
Apologies, could you repeat the beginning of that question?
Do you have a recollection of, at any stage prior to ceasing acting as Chief Counsel, communicating to Ms Kruse that the Legal Services Division recommended that external advice from AGS be sought?
I don't have an independent recollection of that, but to provide a little bit of context, if I may, I was speaking to Ms Kruse throughout the week iteratively. My expectation will be that that has come up in our discussions over the course of the week.
That is, your expectation is that you did communicate to Ms Kruse that the Legal Services Division did recommend that external advice from AGS be sought?
That we were considering the extent to which it might be prudent, and that I had reached out to AGS. I would expect that that would be something I had flagged with Ms Kruse that week.
Okay. What about that, based on the analysis that the lawyers assisting you had done to that point, it would appear that the arguments in support of averaging were weak?
I don't have a specific recollection of it, of a particular discussion to that effect. believe I will have been keeping Ms. Kruse broadly informed, but I can't recall a specific discussion like that.
Well, given the state of the arguments as you saw them in the draft AGS advice, sorry, pardon, I'll withdraw that and rephrase. Given the state of the arguments as you saw them in the draft averaging advice, do you agree with me that acting in accordance with your usual practice, you would, in the course of that week, communicate to Ms. Kruse that it appeared that the arguments in support of averaging were weak?
I think I will have indicated that there was some uncertainty.
Okay.
Well, you did that advice, if we can have that up, 375400010001. And it's an adaptation of Mr. Gladman's advice, isn't it? You've retained some bits of it, but you've added some other bits. It's at
Your tab 102.
tab 102 is one version of it.
Exhibit 5902 for the record, Commissioner.
So apologies, Commissioner, this advice was an adaptation, you were saying?
Well, you've kept some bits of Mr. Gladman's advice and added others of your own.
Yes.
And if you go to the second page, one of the bits you added was an argument that perhaps it was reasonable and efficient to proceed on the best evidence or information that it has, for the department to proceed on the best evidence or information that it has available.
So this was an adaptation pulled together. I won't have prepared it myself. It will have been in consultation with Mr. Gladman and others, and that that paragraph, I believe, was different to what was contained in the draft averaging advice.
Right. Any idea where it came from, this notion of best information or evidence available?
I think that at the point of preparing this, so at the state that we were in that particular week, a lot of the questions we were being asked were questions about using information in order to identify a discrepancy and a possible overpayment. And I think that when we were talking about procedural fairness to individuals, we were talking in a sense about the change in the process whereby individuals were, rather than the department going to the employer, the department was going to individuals, and whether they had a basis to go to individuals to ask them to clarify that information. So my understanding is that reference there to procedural fairness was about the appropriateness of discussing the information or allowing the customers to clarify the information.
I'm talking about the second last paragraph, which is not just about identifying a discrepancy or flagging an overpayment. It is about the department arguing in respect of a decision to raise a debt that it's making the decision on the best information available at the time. And I'm wondering where that notion came from, that somehow it's not a question of whether you have probative information, but whether it's the best available information.
I can't recall, I'm afraid, where that information came from.
Well, it's a statement as to how raising a debt may be legally justified. And I'm just wondering how a lawyer could come up with this proposition that the best available information makes it permissible, even if that regardless of whether that information's actually probative.
I think in the period of time that we were drafting this, we were under the impression that the information, noting that things have moved on over time, we're under the impression that the information from the customer would be information that we could rely on to make a decision.
The information from the customer.
So if we had clarified, if we identified a discrepancy, wrote to the customer to clarify the extent to which that was correct or not, that response would help form the basis of whether it was appropriate to proceed.
But the whole thrust of this is as long as the customer has the chance to comment, that's good enough, not that the customer must have commented.
I
This
think
is about averaging, not about getting a response from the customer and using it.
at that stage, when I was involved in the matter, our understanding was that the customer would be contacted to comment.
Sure. And if the customer doesn't respond, the department would use averaging to raise a debt. And what you were saying here is, that's fine if that's the best available information, without any regard to whether it's actually probative. And I wonder how a lawyer could say that.
I'm not sure that I have anything else I can add to it.
Well, the other thing that's notable in the advice is there's not a single section of the Social Security Act pointed to justify the use of averaging.
No, but
And Mr Gladman had made the point in his advice that there actually were provisions permitting averaging in particular circumstances, for example, in relation to parenting payments, in sharp distinction to income support payments of the types being dealt with in the Robodebt scheme. That seems to have been left out of this advice.
I can't recall that being necessarily a deliberate omission. The work that I was doing at that time was heavily reliant on the advice of Mr Gladman and other people who had greater experience than I with social security law and the relevant payments.
Look, to put it bluntly, this is about as lame an advice as you could get, isn't it? And do you agree with that? As a legal advice, it's really unconvincing.
I agree that it's unconvincing. I think it was a note prepared as a wrap-up of some thoughts at the time. I would certainly prefer in hindsight if it was clearer about the lack of clear instructions and if it was clearer about some of the issues being premised on the, the complexity of the social security law and the possible, the position that it might be prudent to get some external legal advice to support it.
Well, was this made clear to Ms Kruse that this advice wasn't really going to hold up?
I don't think that this was seen as something at that point that was more than considerations and points that we had looked at over the course of that week, that coupled with other correspondence that had been sent to Ms Kruse over that week. So it was very much a draft at the end of the week as I was leaving, to be coupled with a range of other documents like the draft instructions, the averaging advice and other pieces of correspondence. So it wasn't seen, I don't believe, as something that should be standing alone as the basis upon which to proceed to do something or not. It was one element.
What was the point of it?
I can't recall a summary of some of the points that we had that week. I can't recall any more.
Right, thank you.
Thank you, Commissioner. Given, as you've acknowledged, Ms Carmody, that the arguments that were able to be developed by that stage were unconvincing, wasn't it absolutely clear that the prudent and sensible course would be to get external advice on the lawfulness of averaging?
That was clear to me.
And knowing your obligations as a lawyer and as a public servant, can you think of any reason why you wouldn't have made that clear to Ms Kruse?
I think that we will have made it clear to Ms Kruse, but I also think it was a point in time, 5 business days, while we were responding to a range of other matters. We had commenced the process of preparing to engage external legal advice on it. I had reached out to Mr Hardiman. We had prepared the averaging advice, and we prepared a range of materials for handing back, as it were, for me to hand back, noting that Mr Gladman would continue in the role until Mr Stipnex returned. So, I am comfortable with that in terms of my obligations at that time.
But just to be absolutely clear, that you think you would have made clear to Ms Kruse that the prudent and sensible course was to get external advice from AGS.
I don't know whether I will have used those words, but I think I will have made clear to Ms Kruse that I had contacted AGS and that we had prepared the averaging advice with references to that in it.
Do you think you made clear to her the extent of the legal risk that the department potentially faced if legal advice from AGS were not obtained?
Could you repeat that?
Do you think you made it clear to her the extent of the legal risk that the department potentially faced if legal advice from AGS were not obtained?
I don't recall anything as specific as that. As you know, I said earlier, it was reasonably early and it was a small period of time, but we were working on the premise that we were preparing the draft instructions, and we had contacted AGS, so I think it will have been clear. Whether I made it clear, I can't recall.
But surely you did, given that you'd identified before you ceased acting that the arguments in support of averaging were unconvincing.
I think it will have been clear at the time from the various discussions we were having and based on what we knew. However, we hadn't been asked by the relevant area in the department. Like, we'd had the email from Mr Menzies McVeigh on the 6th, but we didn't have other instructions asking us to prepare anything particular. We were just in the process of pulling all of this together in response to that email.
Well, you said, I think it will have been clear at the time from the various discussions. What do you mean by that?
Well, I think what I mean by that is if I had a draft email from Mr Gladman and I had correspondence that I'd sent back to Mr Gladman confirming that I had reached out to Mr Hardiman of the Australian Government Solicitor, and we had the averaging advice with recommendations in it around the extent to which it might be prudent to seek legal advice, that will have been the general tenor of the discussions throughout the week.
That is with Ms Kruse?
I would believe so, yes.
that can be taken down.
Commissioner, I note the time. Is it intended to take the morning tea break? I will have some follow-up.
Hoping that we're nearly done, but
I will have some follow-up questions and need to
yeah, all
confirm
right,
some
we'll take the break.
instructions.
And we'll come back at past. Thank you.
All rise. The Commission stands adjourned until 12:15. The Royal Commission is now in session. Please be seated.
Just before you start again, Mr Scott, Ms Carmody, are you sure somebody in DHS or DSS didn't suggest that notion of the best available information or evidence?
I've got it.
I can't recall I certainly don't recall discussing it with, I personally didn't discuss it with DSS. Within DHS, it's possible that that was a discussion that was occurring, but I can't put my finger on a particular time or moment.
Just that it pops up in a lot of documents like an infection, and I don't understand what the source of it is. All right, thank you.
Paragraph 50 of your statement, Ms Carmody, on page 12, you refer to Ms Mussolino returning from annual leave on the 16th of January 2017, a meeting for a handover on the same date.
Yes.
And we don't need to go to it, but would you agree that you've identified in your preparation for today a calendar entry to indicate that such a handover occurred?
Yes.
Do you have a specific recollection of what was discussed relevant to the averaging advice and the AGS draft instructions at that meeting?
I don't have a specific recollection of it, no.
Well, you refer in that paragraph to providing her with a hard copy folder of all relevant documents from the week.
Yes.
Those 2 documents would be relevant documents from the week.
Yes.
Can you think of a reason why those 2 documents would not have been put in that folder?
No,
Is it your expectation that you would have put those documents in the folder?
it is.
And given that as things stood, by the time you ceased acting on the 15th of January 2017, included a view you held that the arguments in support of averaging were unconvincing. Do you expect that you would have at least communicated that view to Ms Mussolino?
I expect that the discussions in the Broad would have included that view, yes.
And also that a view had been formed by lawyers within the Legal Services Division that there was a need to get AGS advice?
Yes.
Okay. Can you just have a look at your tab 70, Ms Carmody?
70?
Yes. Exhibit 5873, doc ID CTH.30008.0016.3799.
Yes.
Now, that's an email chain that culminates in an email from yourself to Ms Mussolino on the 10th of January 2017. You see that?
Yes.
Responding to an email from her on the 10th of January 2017.
Yes.
With the words "for action" from her, relating to an earlier email that day concerning some media issues. You see that?
Yes.
Now, Ms Mussolino, of course, was on leave at that time,
Yes.
but notwithstanding that, she communicated with you in this email on this matter on that date, correct?
Yes.
In your experience working with Ms Mussolino, did she from time to time communicate with lawyers acting in her position while she was on leave?
I don't know if I recall it specifically, but from time to time, she probably did, yes.
One last document to show you, Ms Carmody, your tab 89. Exhibit 5889, doc ID CTH.311.311.004.7296.
Yes.
See, that's an email from Mr. Gladman to yourself, dated the 11th of January 2017.
Yes.
It's CC'd to the Chief Counsel's office
Yes.
email address. What's the Chief Counsel's office email address?
That is the sort of what we'd refer to as the positional email address that Ms. Mussolino's office staff would be monitoring
For what purpose?
to review correspondence, to track correspondence, to ensure that something that is sent to that address, if it has been sent to the wrong address, could be forwarded to someone else, etc.
Right, and would Ms. Mussolino have access to emails addressed to the Chief Counsel's office positional email address?
Probably. It depends how you've got your email settings up. So, did you ask if she'd have access to that sort of email box?
Yes.
It's possible. Yes.
But members of her staff certainly would.
Yes.
And was it their practice to print emails to that email box and provide those printed emails to whoever was occupying the Chief Counsel role at the time of those emails?
I believe so, unless they felt for some reason that they should forward it electronically and discuss it. But typically, I think that's what they would do.
Okay. Commissioner, that's the evidence.
Ms Hogan-Doran?
Ms Carmody, I just want to seek your assistance for the Commission in terms of just sequencing some of the material that you've been taken to.
Yes.
Just take you back to Tuesday, the 10th of January 2017, and I appreciate there's a large number of emails in the bundle. I just want to take you to three.
Yes.
Tab 41, which is Exhibit 5846.
Yes.
You see that's an email sent to you at 12:16 p.m,
Correct.
which is the email from Mark Gladman with the draft note to Leo,
Yes.
and that's Leo Hardiman at AGS.
Yes, it is.
All right, go across to tab 42, which is Exhibit 5847.
Yes.
And that's an email from you at 12:30, responding to that email we've just looked at from 12:16,
Yes.
raising two things before instructions can be activated.
Yes.
Right. Could you then go across to tab 43, which is Exhibit 5848,
Yes.
which is at 12:37.
Yes.
Now, you were taken to this email is you reporting back to Mr. Gladman or informing Mr. Gladman in relation to your call with Leo Hardiman.
Yes.
Now, you were taken to those two last emails in reverse order. That is, you were taken to your email concerning your call with Mr. Hardiman and then taken to the 12:30 email, which is your point about two things that need to be done before instructions can be given to AGS.
Yes.
Can you assist the Commission by identifying, if you can, when it was that you spoke to Leo Hardiman? That is, was it between 12:30 and 12:37, or was it before you wrote both of those emails?
Looking at the emails, I believe it was likely to have been between 12:30 and 12:37, but it's possible, I think, that I had initiated contact prior to 12:30. And he's returned my call between those two because I didn't comment at 12:30 on him having returned my call.
And when you spoke to Mr. Hardiman, I take it you didn't have formal instructions from the client area to instruct AGS at that time?
That's correct.
And do you recall making that clear to Mr Hardiman?
I don't recall making it clear, but in my experience, when I have a discussion with a lawyer in relation to a matter, it is sometimes to foreshadow that we may need to contact them with formal instructions in sort of a short period of time, and to ascertain, as I think in this case, whether they will be available to support and whether there is anything else that, any other information that they might have or request at that time.
So you'd confirmed he had capacity and that he had the relevant experience that was required for the question?
Yes, because I was familiar with Mr Hardiman having done other work with, at AGS, but I had not instructed him in relation to social security matters because I had not worked on those matters.
You had taken just a moment ago to an email from Ms Mussolino, also on the 10th, but much later that day.
Yes.
Did you have any conversations with Ms Mussolino
Not that I recall, no.
in the period in which you were acting?
Not that I recall.
All right. If we go across then to the 13th, the Friday, and could I have you look at tab 101, which is Exhibit 5901? And this should be an email from you to Mr Brazel and Mr Gladman.
Yes.
All right. And that's at about 5:09 p.m.
Yes.
And could I just keep that up on the screen, but have you turn over to tab 102 and add in Exhibit 5902? Are you able to assist the Commission to indicate which one of these came into existence first?
The one under tab 101, ending in 4126, I believe will have come in to assistance first because I've asked Mr Brazel and Mr Gladman for their thoughts on it, as was my practice that week as we're working on a lot of these matters together. And then I expect what has happened is I've had a conversation with them about it. Potentially one or both of them has attended my office, and I've, in a sense, top and tailed that note to add the opening remarks to Ms Kruse and that first paragraph.
You've said just now potentially having a conversation with Mr Brazel and or Mr Gladman.
Yep.
Do you recall having a conversation with anyone else within the Legal Services Division in relation to the preparation of either or both of these notes?
I don't recall that, no.
Were you aware of a legal officer by the name of John Barnett?
Yes, Mr Barnett worked for Mr Stipniks and Mr Gladman while Mr Gladman was acting in that role.
Do you recall having any conversations with him?
I do recall conversations with Mr Barnett that week. I do not recall whether it was specifically in relation to this note or in relation to the averaging advice, and other pieces of correspondence. But I don't recall. I don't have a great deal of detail that I recall.
Did you have any reason to deal with Mr Barnett outside the course of that week?
No, I didn't. So having come from the commercial law branch and acted in that role on the Monday, it wasn't typical for me to engage with the lawyers, other than on occasion the branch heads from other branches. My practice was, predominantly property, corporate, intellectual property matters. So on occasion, I may have spoken to him, or people in my branch may have spoken to him in relation to social security matters, but not me, as far as I recall.
Just two final questions. Just mentioned the branches. What were the different branches at that time?
Now you're testing me. I was the branch head of the commercial law branch. There was a litigation branch, an FOI branch that may have been combined with an employment law branch. At different times it has been combined. The program advising branch, which is the branch where Mr. Gladman was acting in the role, and that was the area that dealt with the program matters and a lot of the legislation. And there was also a branch that was called Business Transformation Legal that did a particular type of corporate work related to some of the department's transformation work at the time.
And in your evidence, you've given some references to having discussions, including discussions with Mr. Gladman, Mr. Brazel, and Ms. Kruse.
Yes.
Were you all co-located in that week?
We were. So we're all, the legal division at that time was based on a particular floor in the same building. The acting deputy secretary and traditionally the deputy secretary are also located on that floor. There are some lawyers who are not. Mr. Barnett, I don't believe, was based in Canberra, but most of us are, and so it was quite common to sort of race around from one office to another to talk about things rather than necessarily all the time have emails at paces. Sometimes it was faster.
And you've referred to the acting deputy secretary. Is that the acting deputy secretary in the week that you were acting as chief counsel?
That's correct. The week that I was acting as chief counsel, there was an acting deputy secretary in that role, and that was Ms. Kruse.
And whose name was that?
Ms. Kruse, Sue Kruse.
Right. And what about acting secretary?
I believe there was an acting secretary in that at that time as well, Mr. Jackson.
All right. And where was he located?
He was also located in that building, I believe. The secretary was located in that building, so I believe the acting secretary probably sat in that office at that time.
And when Ms. Musolino returned from leave in the week commencing the 16th of January,
Yes.
was she co-located with you?
Yes, she will have returned to her office. My office was on the other side of the floor, situated with my branch, but we were in the same space broadly.
Do you recall having any conversations with Ms. Musolino in the period after she returned and after your handover concerning the obtaining of AGS advice?
I don't recall any specific discussions. I do know there was some correspondence from Ms. Musolino where she wrote to the cohort of general counsel, so each of the branch heads of those branches I named before, asking for any legal advice that may have given that related, earlier legal advice that related to the matter, and also a meeting that had been coordinated to discuss external legal advice, I believe, coming out of a meeting that Ms. Musolino was intending to have with the deputy secretary, two deputy secretaries, the deputy secretary of the program area and the deputy secretary of the enabling area. But I don't recall the details of any discussion from that.
Right. I'll just have that document that I think you've just referred to brought up. I think it's behind your tab 139 possibly. CTH.3007.0004.3604. I'm not You can see there's an email of 23 January 2017 at 9:51 a.m. from Ms. Musolino to a number of people, including you, asking to please check in their branches and identify and provide to me any legal advices, internal or external, provided by legal to the business regarding debt recovery Centrelink overpayments. Is that a response from you at 9:58 a.m. on that?
Yes. Yes, so that is my response at 9:58 a.m. Yes,
And then Ms Mussolino's response to you for that week, I think I have everything that was printed. I'm more interested in anything done previously.
that's correct.
No further questions. Thank you, Commissioner.
Yes, Mr Scott.
Just briefly, Commissioner, can I just clarify your evidence arising from your exchange with Counsel for the Commonwealth? Is it your evidence that, notwithstanding the unconvincing nature of the arguments in support of averaging that had been identified to you, you didn't have any conversation with Ms Mussolino about how unconvincing you regarded those arguments to be?
I don't recall that being my evidence. I had a handover meeting scheduled with Ms Mussolino, and I had the documents that were provided, but I think, I mean, I'd have to go back and check the question, but I think the question was about other specific conversations, and I indicated that there was the calendar invitation and this email that we had talked about moments ago.
Yes. So my question is, after Ms Mussolino returns from leave, I'm asking you about any conversations you had with her where you communicated your views as to the unconvincing nature of the arguments as you saw them in support of averaging.
I can't specify what particular conversation I had and when, but I will have had a range of conversations with Ms Mussolino as the Chief Counsel at the time, and with me back in my usual role as General Counsel, including the handover conversation, where I think it will have been clear the draft advice that had been prepared, the engagement that I'd had with Mr Hardiman during that week, and the general sense that there are still things that we needed to explore.
So when you say it would have been clear, you're saying it would have been clear from the documents you provided Ms Mussolino?
I think it will have been clear from the documents that I provided to Ms Mussolino. I think as well it will have been clear from the continuing correspondence that she will have had with Mr Gladman, who was continuing in his role as the acting head of that program advising branch when I had returned back to my commercial law role.
You didn't add anything to those documents in your discussion with Mussolino about your own views about the unconvincing nature of the arguments?
It's possible that I did, but I just can't recall all of the conversations that I had with her. I mean, I think it will have been inherent in the discussions we were having about what had transpired that week and the recommendation in the averaging advice that it might be prudent to seek external legal advice, but we were still pulling together the facts and the information, and I believe she was still pulling together the existence of any earlier relevant advice.
Did you communicate to her the extent of steps that were needed to be taken in order to brief AGS?
Could you repeat that, sorry?
Did you communicate to her the extent of any steps that were needed to be taken in order to brief AGS?
I don't recall specifically communicating with her about that. She would have, I would expect, like in the usual course of events, the branch that was working to me at that time would then be working to her when she returned, and they would continue any work that was unfinished.
What about the fact you'd contacted Mr Hardiman? Did you communicate that?
I believe that I will have communicated that, yes.
Commissioner, that's the evidence of this.
Thank you. Do you want Ms Carmody excused?
Yes, please.
Yes, you're excused. Thanks, Ms.
Thank you.
Carmody.
Before the next witness is called, Commissioner, I need to tender some further documents. Firstly, the additional documents produced through the supplementary statement of Ms Kruse need to be tendered. They, I understand, are listed in the index to the supplementary tender bundle that may have been provided to you, Commissioner, and they should be those documents which are numbered 2 through to 6 in that index, which will then give them exhibit numbers 5938 capital A through to 5938 capital E.
Right, 5938A to 5938E as listed in this index.
Thank you, Commissioner. I also seek to tender the exhibits relating to the evidence of Mr Andrew Podger, including his expert report, which will be exhibits 6019 through to 6039.
Yes, they'll be admitted with those numbers.
Thank you, Commissioner. I call Sue Kruse.
Yes, Ms Kruse, will you take an oath or an affirmation?
An affirmation,
All right,
Commissioner.
thank you.
The response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr Scott.
Thank you, Commissioner. Ms Kruse, would you please tell the Commission your full name?
Susan Margaret Kruse.
And you are retired?
I am.
Thank you. You were provided a notice to give information in writing and produce documents from the Commission, which notice is dated the 14th of February 2023.
I was.
Thank you. And you produced initially a statement dated the 19th of February 2023 in response to that notice.
I did.
Thank you. And then produced a supplementary statement dated the 26th of February 2023.
That's correct.
Thank you. Are the contents of your two statements true and correct to the best of your knowledge and belief?
I'm sorry, could you repeat that?
No worries. Are the contents of your statements true and correct to the best of your knowledge and belief?
They are.
Thank you. Now, is this right? Between September 2016 to 4 April 2017, your substantive position in the Department of Human Services was General Manager, Whole of Government Coordination.
That's correct.
But between the 23rd of December 2016 and the 16th of January 2017, you held the position of Acting Deputy Secretary, Enabling Services.
That's correct.
The substantive holder of that position at that time was a Mr Jonathan Hudson, correct?
Correct.
Who was he on leave at the time?
Yes, he was on annual leave.
Okay, and returned from annual leave on...
17th of January.
Thank you. And then he resumed occupying the role
He did.
and you ceased acting.
And I went back to my substantive position.
Thank you. All right. I want to commence my questions, Ms Kruse, with the subject matter dealt with in your supplementary statement.
Yep.
And by the way, I should say that to the extent I go beyond that statement to particular documents that I'm going to ask you questions about, they should be in that large folder that you're holding onto there.
Okay.
But if we can start, please, with your supplementary statement, paragraph 10. You referred to two discussions that were scheduled on the 4th of January 2017.
Sorry, I'm just, my supplementary statement, which tab would that be in?
Should be tab 1, I'm told.
No, that's my full statement.
Is there a smaller folder to your far right?
Oh,
It's perhaps the case that your supplementary statement is in a folder that looks like this, Ms Kruse?
no, that's this one here.
Okay. Not behind tab 1?
Yeah, I've got tab 1, but paragraph 10, it just says I was given access to the AGS Outlook calendar and diary.
I have that folder shown to me, please. Let's see what the story
Sorry.
is. Thank you. Oh, right. Yeah. I'll have that handed back. Tab 2. No. Yeah. All right. That can be handed back. Is that folder now open to have your supplementary statement in it, Ms Kruse?
That's correct.
Thank you. Could I ask you to go to tab 10, sorry, paragraph 10, please? Have you got paragraph 10 there?
Yes, I do.
Okay, so you refer to a review of your Outlook calendar showing the following meetings scheduled on the 4th of January 2017. And that comprises 2 discussions, the first one being with Barry Jackson, Melissa Golightly and Mark Wood at 12 p.m. And then the second one is a discussion with Barry Jackson, Melissa Golightly, Karen Harfield, yourself and Minister Porter at 4:30 p.m.
Correct.
Okay. And could I ask you to go to the tab 10 of the large folder, please?
Yep.
Have you got that there? That should be exhibit 5816, doc ID SKR.0001.00272.
Correct.
Okay. And do you agree with me that that is an email chain on the 4th of January 2017?
That's correct.
And that chain commences with an email from Ms Harfield to Ms Golightly dealing with an explanation of the assessment methodology.
Correct.
And then there's a further email, CC to yourself, addressed to Barry Jackson and Mark Wood.
Yes, correct.
We're referring to 2 customers that the 7:30 report has provided.
That's correct, yeah.
Have you had an opportunity to review this email chain in preparation for today's evidence?
I have, yes.
And can you assist us as to whether or not it has any relevance to the 2 meetings on the 4th of January that you referred to in your supplementary statement?
Well, the meeting on the 4th of January was to prepare Minister Porter for the 7:30 report that he was going on to talk about the online compliance system. So apparently what the reporter at the 7:30 report wanted to discuss was about 2 individual customers who had reported to them about the debt that had been raised. Okay. So that's what this email was about.
And do you have a recollection of attending those 2 meetings?
I do vaguely remember attending the Minister Porter meeting. I don't recall the first meeting with Mark Wood, but having read this email, obviously I was there, but I don't. I've been in the role 24 hours where this was occurring, so 6 years ago, and I'm not.
Well, based on your general knowledge of how interactions with ministers would generally occur.
Yep.
Can you assist us as to why there might be a meeting with Mr Wood before the meeting with Mr Porter?
Well, the meeting with Minister Wood was with Mark Wood, the advisor, was to find out from the advisor exactly what Minister Porter wanted to know so we could be prepared with all the information we needed, such as there was a need to send screenshots and workflows as well as information around these two customers so that when we spoke to Minister Porter that afternoon, he would have that information, we could talk it through with him, and then he would be prepared for the 7:30 report.
Okay. And so in the meeting with, I'll withdraw that. What is your recollection of what occurred in the meeting with Minister Porter?
To be honest with you, my recollection of that meeting was that I didn't say much. Ms Golightly was the main person because she was the program owner and she knew more about it than the rest of us sitting in the room, except for Karen Harfield. It was over the phone. Minister Porter was in Perth, I recall that. And I recall Minister Porter, normally we would provide talking points to a minister that if he was going to go on any media or anything like that, and he was typing up his own notes. And I found that quite an unusual thing to do for us not to have provided something and then for him to type up his own notes. So that was my main recollection of it.
So it was a meeting over the phone?
Yes.
With Mr Porter?
Yep. Yeah.
Who was where?
He was in his Perth office.
Okay.
Or he's in Perth. I don't know whether he's in his office or not.
And where were you located?
We were located in Canberra in the Secretary's office.
Right. And who was present in the Secretary's office at the time?
It would have been Melissa Golightly, Barry Jackson, the Acting Secretary, myself and Karen Harfield.
Okay.
And Mark Wood was on the phone from wherever he was.
And was it on speakerphone?
Yes, it was on one of those round conference phone things, yeah.
So you could hear what Mr Porter was saying?
Yes, yeah.
You could hear him typing on his
Yes.
computer?
Yes.
And you could, if Mr Wood spoke, you could hear him?
Yes.
Okay. But am I right in understanding your evidence that in general the talking by those present at the place where you were was done by Ms Golightly?
That's correct.
Okay. And doing the best you can you assist us as to what Ms Golightly said during the meeting?
Given the information that we've got here from Karen Harfield, I'm assuming it was about the fact that we'd moved a system from a manual process to online. It was a process that had been undertaken since 1981 or earlier. There would have been some discussions around the workflows, I assume, and an outline of the customers and their debt and how they were raised.
Okay. The information we've got from Karen Harfield you just referred to is the information contained in the first email in this chain?
Sorry?
The information you referred to from Karen Harfield, is that the information from the first email from Ms Harfield in this email chain?
Yes, yes.
Do you have a recollection whether what Ms Golightly said was generally consistent with what Ms Harfield said in this email?
I don't, but I would assume it is, yes.
Okay. Do you have a recollection that after this meeting, Minister Porter did appear on the 7:30 report?
Yes, he did appear.
Okay. Now I'm going to show you an email which should be in the supplementary bundle you have, which is that smaller bundle. And I'm crossing my fingers it is, behind tab 5.
5.
Doc ID SKR.001.001. Exhibit 5938, capital D. Is that an email from yourself to Barry Jackson and others on the 4th of January 2017?
That's correct.
Okay, thank you. And am I right in understanding your evidence based on your supplementary statement that this is your summary of what Minister Porter said on the 7:30 report based on what you saw him say?
Correct.
Okay. Now, I'll just call out the first sentence of that email, which is, the Minister did a good job. Airtime was mainly given to the individuals and the lawyers from Victorian Legal Aid, who was trying to say that social security law was not being followed by averaging over the year. See that?
I do, yeah.
Now, do you have a recollection that is a reference to the lawyers from Victoria Legal Aid identifying that the use of averaging ATO income data to calculate social security entitlement was contrary to the social security law?
Well, that's how I'm reading it, yes.
You have a recollection that's what they said?
Well, I've typed it up, so I'm assuming I was accurate in my assessment when I typed that up, yes.
Do you have a recollection of the 7:30 report beyond what appears in this email?
No, I don't, sorry.
All right. The next documents I want to take you to, Ms. Kruse, appear in the large folder that you have.
Why were you telling all these people about the content of the 7:30 report? Do you know? Would they not have watched it too?
Yes, they would have watched it, and the media team watched it as well. And because my acting role at that time included the media unit under my responsibility, I was watching it and sent it off as part of the role that I was playing at the time.
Thank you.
Do you have a recollection whether at the meeting with, I should say the telephone meeting with Minister Porter on the 4th of January, whether there was any mention of legal advice?
No, I don't, no.
Or whether or not any views were expressed by Ms. Golightly or other departmental officials as to the strength of the legal position that the department was relying upon?
No, I honestly don't have any recollection.
Okay. The next document I want to show you should be behind your tab 18 of the large folder, Ms. Kruse. Exhibit 5824, doc ID skr.0001.001.0026.
Yes,
And do you agree with me that's a chain of emails on the 5th of January 2017?
correct.
Thank you. And the first email in the chain is from Ms. Golightly at 6:59 a.m. And these words appear, all I think we should be think about including, if we haven't already, lines re safeguards we have for people. Do you see that?
Correct, yep.
Now, the term lines, is that a term that refers to words that are used to respond to media inquiries?
That's correct, yeah.
In other words, media lines?
Yes.
Okay. And is this an email discussing potential lines for dealing with media inquiries?
Correct.
Okay. And then the next email on the chain is from yourself, dated on the same date at 8:26 a.m.
Correct.
And you say, Melissa, aside from the lines for assistance, should we be looking at whether we should be hitting the legal angle the legal aid lawyer seems to be pushing?
That's correct.
See that? And that legal angle would be, wouldn't it, the issue that the Victorian Legal Aid lawyers had identified in the 7:30 report program about the lawfulness of averaging. Would you agree?
No, that was more about the fact that if you read through the media of the time, it was that there wasn't enough time provided, or people weren't getting the 21 days from the time the initial letter went out before a debt was raised. So it was to cover all of the anything that the legal profession was saying at the time. It wasn't just around the averaging, it was around everything.
Okay, but in any event, one of the issues that had been identified by the Victorian Legal Aid lawyers in the 7:30 report program, as you identified in the first sentence of your summary of that program, was the lawfulness of the use of averaging.
No, what I would say is that this email is not necessarily related to my email of the day before. It is related to the amount of media we were actually getting in all at that time. I mean, was copious quantities of media around a whole range of things, so it wasn't just about the 7:30 report.
Okay, well, in any event, if you could just please listen to my question.
Yeah.
You agree with me that one of the issues that was identified by Victorian legal aid lawyers in the 7:30 report program the previous night was the lawfulness of the use of averaging.
Yes, that's correct.
And that was one of the, to use your words in this email, one of the legal angles the legal aid lawyer was pushing.
Correct.
Thank you.
And certainly Ms Golightly doesn't seem to have thought you were talking about whether 21 days was allowed, because she responds with saying that you should all stick to the formula that it had been used since 1981.
That's correct, yeah.
And that would relate to the lines dealing with averaging, which referred back to the history of the use of averaging.
Yes, that's correct.
And also that it's only used if you don't respond. That was a standard line, wasn't it? And that's what Mr Porter had said.
That's right.
May we take it that your suggestion or proposal to look at hitting the legal angle might be a suggestion that legal advice be obtained?
No, it was about getting lines for media because there was so much media coming in at that time. We needed to have sort of standard lines that we would send back to various things. Then everything had to go back through Ms Golightly to be cleared before it got to the media. So we and the media unit were looking for lines to cover just about everything so that, you know, they could pull together responses quickly in very short timeframes.
Well, lines that would represent a legal position would need to be informed by legal advice, wouldn't it?
Well, most of anything that came through that would go through the legal team, absolutely.
Right, so isn't this a
But
suggestion?
at this stage, Ms Golightly didn't want us to do anything around that, so we didn't pursue it.
Yes, that was my next question.
Yeah, sorry.
She obviously pushed back against that suggestion, didn't she?
She did, yes.
Yep. The next document I will show you, Ms Kruse, is behind your tab 24 of the large bundle, doc ID skr.0001.001.0054, exhibit 5830.
Correct? Yeah.
Now, there's a reasonably large body of material behind that tab, but I'm interested specifically in the email chain on the first page. Commencing with an email from Mr Jackson dated the 6th of January 2017 at 5:24 p.m. As I think you've acknowledged at that stage, Mr Jackson was acting secretary of the department.
That's correct.
And his email says, "Hi, did we find out whether the averaging is in the ledger or the guidelines, and if so, where?"
Correct.
Not meaning to be critical of his spelling, I'm sure he was quite busy at the time. But the way that email reads is as if there had been a prior discussion about whether or not averaging is in the ledger, that is legislation, or the guidelines. Do you see that?
I do, yes.
And do you accept do you have a recollection of such a prior discussion?
No, I don't, sorry.
But is it consistent? Do you accept that such a discussion must have occurred?
I accept a discussion must have occurred, but I don't know who with,
Okay,
or I don't recall who with.
all right. Well, then there's an email from Ms Golightly.
Mr Scott, just before you go on, it is just after 1. If you're not going to be too long, we could keep going, but and if you tell me that there might be some pressure on this afternoon, we can come back a bit earlier. But what do you want to do? I'm happy to sit till 1:30 if you'd like and come back at 2:30 if there's some concern about this afternoon's witnesses.
I don't think there's too much concern, and my apologies, I completely lost track of time, Commissioner.
I know we were having such a good time, I can quite understand. Well, are you happy to adjourn now till 2:30, or do you want to go on a little?
I think it'll take more than 15 minutes for me to finish this witness. Perhaps if we kept going on, I think we'd probably be still going by 1:30, but not much longer. But I'm happy to adjourn.
Okay, we might come back at 2:30 if you think there's no great strain for getting the other witnesses finished. Thank you.
All rise. The Commission stands adjourned until 2:30 p.m. Royal Commission is now in session. Please be seated.
Commissioner,
Yes.
might I indicate my instructors have been in contact and made contact with Mr Barnett over the luncheon adjournment. We will be working with him to provide a statement as soon as possible.
All right. Did he get in touch with you or did you find him?
The phone number that was made available by Mr Gladman was used to contact him, which was different to the number that I'm instructed we had.
Great. Thank you.
Thanks, Commissioner. Ms Kruse, could return to the document we were discussing before we broke behind your tab 24, the large volume. Exhibit 5830, doc ID skr.0001.001.0054. You might recall I made an impertinent remark about Mr Jackson's spelling in his email at 5:24 on 6 January 2017. I'm going to ask you about that email from Mr Jackson in a little while, but I need to provide the context to that question. So I'll identify that context now. Firstly, if I can draw your attention to Ms Golightly's response on that same day, the 6th of January 2017, which is on that page, and says, "Hi Barry, we were going to check this with Paul Menzies McVeigh, who has been tied up with the Certificate of Public Interest." That this, in that statement, you accept, is a reference to his question about whether the averaging is in the ledger or the guidelines, and if so, where. You agree?
Right, yeah.
Thank you. And then she continues, "We have confirmed that it is at least in the policy as advised."
Correct?
Do you agree with me? That's a reference to some advice at some stage that it is supported by the policy.
I agree, yes.
Do you have a recollection as to who gave that advice?
No, I'm sorry, I don't.
Okay. And then it says, "The advice from legals re the legislation is that it is a very complex job to get the answer. For example, the legislation clauses for each payment are different." They have started on this, see that?
I do.
And then it says, "Also, in the meeting with the Ombudsman today, it was apparent that they are interested in getting more info around how we do averaging." She says, "Don't they," must mean don't think they asked a specific question re-ledge, but we are preparing in case they do, which would not be a surprise. See that?
That's correct, yeah.
Do you agree that's a reference to preparation being underway in order for the department to answer a question from the Ombudsman about the legislative basis for averaging?
I agree, yeah.
Okay. The next document I would like to take you to is behind your tab 27. Doc ID skr.0001.001.0052, Exhibit 5832.
Yes?
Do you see that commences, that's an email chain commencing with an email from Mr Menzies McVeigh on the 6th of January 2017. See that?
I do, yes.
Same day as the email chain we were just discussing.
Correct?
Quite later, a little bit later at 9:14 p.m. See that?
Correct, yep.
Mr Menzies McVeigh at this stage was acting Chief Counsel for the department.
That's correct.
Thank you. And the subject is legal advice on averaging. You see that?
It is, yes.
And he says, "I confirm that I have set the wheels in motion on this advice as the top priority next week." See that?
Yes, I do.
And then you respond the next morning, well, just after 12 a.m. the next morning, where you thank him for his email.
Correct.
In that context, may we take it that Mr Jackson's email, 5:24 p.m. the previous day, asking whether the averaging is in the ledger or the guidelines, and if so, where, was an instruction to obtain legal advice on that question.
I take it that he wanted to know exactly where the authority for averaging sat. Where did it sit in the legislation or the guide, and he wanted advice about that, yes.
And advice from the lawyers?
Yes, advice from the lawyers would be the ones that could do it.
Okay. And of course, he was acting secretary at that time.
He was, yes.
If that request were to be withdrawn, would it have to be withdrawn by either the acting secretary or the secretary who was in the substantive role when she returned from leave?
Correct, yes.
Sorry, I didn't catch that. Correct?
Correct, yes.
Okay. All right. Now, I want to ask you about, that can be taken down, some documents that are described in your first statement as the draft instructions and the averaging advice. So, firstly, if you could go to your tab 73 in your large folder, Ms. Kruse.
Tab, sorry?
73.
73.
Exhibit 4231, doc ID CTH.3038.0002.6641.
I have that, yes.
Thank you. And if you could look, please, at paragraph 38 of your first statement on page 6. You have that?
I have that, yes.
You see it defines two documents as the draft instructions.
That's correct.
One of those is the document on the screen, and which I've identified to you.
Correct.
The other document with the other doc ID ending 6647 is another version of the same document.
Correct.
Thank you. Now, is it your evidence you were not involved in the decision to prepare the draft instructions?
That's correct. Not that I'm aware of.
And you're not aware of who communicated the decision to prepare the draft instructions?
I'm not aware of any.
Prior to receiving the notice from the Commission, had you seen the draft instructions?
No, never. No. Not to my knowledge had I ever seen them.
Okay. Just want to ask you about what you say at paragraph 45 of your statement, your first statement, which is, had I known about the draft instructions, unless there were extenuating circumstances, I believe I would have considered it to be significant and taken the following steps. Liaised with the legal team to understand these documents, provided the draft instructions to Ms. Golightly to consider as it concerned the program she oversaw, and arranged for the draft instructions to be provided to the Secretary.
Correct.
Okay, and why would you take those steps in relation to this document had you seen it?
Well, I'm not a lawyer in the first instance, so I would require some discussion to understand what the content of these instructions were. The fact that Ms. Golightly owned the program and these draft instructions were being prepared about a program that she had responsibility for, it would be my role to ensure that she, as the Acting Deputy Secretary, was across this and knew what was going on and get advice from her. And then if there was some disagreement about what we should do with this and I needed some further advice, I would take that to the Secretary as the next person in charge of the, who would give me advice.
Okay. The next document is the document you discuss commencing on page 11 of your first statement, which is known as defined or referred to in that statement as the averaging advice. Could I ask you to go to your tab 81?
Tab.
That's doc ID CTH.30430.173.9782, Exhibit 4740.
Correct?
Thank you. Is that what is described in your first statement commencing at the bottom of page 11 and going over the page as the averaging advice?
That's correct.
Thank you. All right, now is this right? And I'm referring to paragraph 81 of your statement, that you did not see or receive any draft or final version of this advice?
That's correct, to the best of my knowledge.
Okay. You say at paragraph 84, had I known about the averaging advice, unless there were extenuating circumstances, I believe I would have considered it to be significant and taken the following steps. And you describe the same steps you described paragraph 45 of your statement in relation to the draft instructions.
Correct.
And may we take it that the reason why you would take those steps, had you seen that document, were the same that you described in relation to why you would take the steps at paragraph 45 of your statement had you seen the draft instructions?
That's correct.
Okay, thank you. That can be taken down. Now, based on the email from Mr Menzies McVeigh to you at 9:14 p.m. on the 6th of January 2017, which you replied to, you're aware that the Legal Services Division was preparing a legal advice on averaging?
Yes.
Where you were...
Sorry, I'm aware because of that email, yes. But do I recall that? No, I don't.
You don't have a recollection of that?
I honestly do not have a recollection of that conversation.
Were you located in the department on the same floor as the lawyers within the Legal Services
I
Division?
was, the same floor as the lawyers and the media.
Right. And were you... how far was your work space from that of Miss Carmody's?
Oh, 100 metres. It was on the same floor. I'd walk out the office, go round the corner through another set of doors that open and close, and then she was located in, or Annette Mussolini's office was located in around there. So I'm not very good on distances.
Okay, but
Maybe
not far.
100 steps.
Would you, just in the ordinary course of any given day, have occasion to see Miss Carmody while at work?
I would see lots of people, yes, absolutely, including Miss Carmody.
Okay. Do you not have a recollection at all of discussing this advice which Miss Menzies McVeigh had indicated was being sought in his email on the 6th of January 2017?
No, I do not.
Do you have a recollection at all of discussing this advice with Miss Carmody?
No, I do not.
Do you have a recollection at all of Miss Carmody indicating to you that there was uncertainty? I'll start that again. Do you have a recollection at all of Miss Carmody indicating to you that there was uncertainty as to the lawfulness of averaging?
No, I do not.
Or that the arguments in support of it were unconvincing?
No, I do not.
Or that the Legal Services Division recommended getting external advice from the Australian Government Solicitor?
No, I do not.
And that, in fact, steps had already been taken to confirm the availability of a lawyer at the Australian Government Solicitor to provide that advice?
I was not aware of that was occurring.
Given your practice, which you describe at paragraph 45 of your statement,
Correct.
and then using similar words in relation to the averaging advice, had you been told of those things that I've just identified, what would be your usual practice?
If I was aware that those things were going on, my usual practice would be to actually talk to the program owner of the various area, the relevant area that the advice was being constructed for, work with that area to just say what was going on, what was required, that there is a problem here, we need to do something about it. I would have no problem seeking external legal advice. I have done it in the past. I don't consider that unusual. And if the program area had reasons for not doing it, I think I would have to take it to the secretary to have a discussion with her about it to resolve the issue.
The secretary being Ms Campbell.
So, yes, certainly. Or at that stage, Mr Jackson,
And
he was acting at that particular stage.
but if he wasn't, you'd take it to Ms Campbell?
I'd take it to Ms Campbell, yes.
Can you think of any reason why you wouldn't?
None whatsoever.
And why you wouldn't take it to the program owner?
No, none whatsoever.
Program owner being Ms Golightly?
Ms Golightly.
Okay. What about when you ceased acting? Did you have a handover with Mr Hudson?
I did, on the morning that he arrived back on the 17th.
Okay, and had you been aware of the matters that I put to you, what would be your usual course in relation to the handover to Mr Hudson?
Well, anything that was hot or critical, I would have provided him an update on where we were at with it and what was occurring.
Would you agree that this was hot or critical?
If I'd known about it, absolutely.
Well, put it this way, there'd been media on the 7:30 report about the lawfulness of averaging.
Yeah, there had, but I had also assurance from the program area that there wasn't an issue with this at the same time. So, I was taking advice from the program area at that stage.
The assurance from whom?
From Ms Golightly, Ms Harfield,
Okay, all right. But in any event, we can take it in steps. There was a lot of media about the program in early 2017.
There was.
And that media included questions about the lawfulness of averaging.
It did.
And so that issue was, to use your language, hot, correct?
Well, I would say it was what we would call a hot topic in the department, yes.
Right. So had you known about concerns about uncertainty with the program, with the arguments in favour of averaging being thought by the lawyers to be unconvincing, that steps have been taken to brief AGS, and in fact they recommended briefing AGS, would you have in your ordinary course informed Mr Hudson of those things at the handover on the 16th January?
I certainly would have, yes.
And sorry, I might have got this wrong. Did he come back from leave on the 16th or 17th of January?
17th was his first day back, the Tuesday.
Okay, so the handover would have been then?
That's right, that morning.
Right. Can I ask you, please, Ms Kruse, to go to page 102, sorry, tab 102 of your bundle, doc ID CTH.3754.0001.001, exhibit 5902. Have you got that?
I have, yes.
That could be brought up on the screen, please. Have you had an opportunity to read this document in preparation for your evidence today?
I have.
Okay. Now, do you agree with me that whilst it is not completely in the same terms as the averaging advice, it uses a lot of the same language as the averaging advice?
It does.
And do you agree with me that there is a notation on the document indicating it was delivered in hard copy to you on the 13th of January 2017?
I do.
And the evidence from Miss Carmody is those words were words that she added to the document. Okay?
Okay.
To accept, therefore, that this document in this form was provided to you in hard copy on the 13th of January 2017?
I don't recall that occurring.
Well, you might
I
not.
mean, it says it was delivered to me. I'm not saying it wasn't. I'm just saying I don't recall receiving it.
All right. Well, given your usual practice that we've discussed in relation to the averaging advice and the draft instructions, can you assist us as to what you would do in the ordinary course if you followed your usual practice upon being hand-delivered this document?
Well, I would have discussed it with the author to understand it greater. I would then, if I thought it was raising any red flags, I would talk to the program area, the same as what I have explained before, and discuss it with them, because at the end, it's their program to have to manage and look after.
You see, you agreed with me that the email from Mr. Jackson on the 6th of January was an instruction to obtain legal advice
That's correct.
on the issue of averaging.
On where the authority for averaging sat, yes. Was it in the law, in the legislation, or in guidelines?
And this appeared to be a draft of that advice produced pursuant to that request by Mr. Jackson.
It does, yes.
And in circumstances where Mr. Menzies McVeigh had indicated to you that advice was being sought as a top priority. Yes?
Yes, correct, yeah.
And you were days away from completing your period as acting as Deputy Secretary by this stage.
That's correct. This was the Friday. I had Monday and then...
So given those circumstances, you surely would have communicated anything that the author of this document said to you about it to Mr. Jackson?
That's what I would have anticipated I would do, yes.
And to Miss Golightly?
Correct.
And if those things which... Sorry, I'll withdraw that. And if the things which the author of this document informed you of included that there were the arguments were unconvincing, there was uncertainty, and that not only was AGS advice recommended, but steps were in train to get that advice, all of those things would have been communicated to those three people.
That's correct, yes.
And is it your evidence that you have no recollection at all of those things being communicated to you by Miss Carmody?
None whatsoever.
It seems a bit extraordinary, Miss Kruse, given the circumstances that we've discussed, that you've got no recollection at all of receipt of this draft advice document. Do you have any comment on that?
No, I haven't. I mean, I don't recall it. I'm sorry, I don't have a recollection of it. I wish I did. I don't.
Given the surrounding circumstances, surely you must have some recollection.
I have absolutely no recollection of it whatsoever. I recall over that period of time a lot of advice being coming backwards and forwards around addresses and letters and making sure letters were going to the right people. I recall multitude of media requests. I do not recall at any stage anybody coming to me and saying there was a concern with the averaging within the department coming to me.
Do you have a recollection at all of the finalisation of the advice which Mr Jackson had requested on the 6th of January 2017?
Pardon me, sorry?
Do you have any recollection at all of the finalisation of the advice which Mr Jackson had requested on the 6th of January 2017?
No, I don't. That was a request to Ms Golightly. I wasn't included in that request. I was included in the email that Ms Golightly then sent, but the actual request from Mr Jackson was to Ms Golightly.
Sure, but you actioned it, didn't you?
Well, I'm assuming I actioned it
Yes.
because I've got an email from Mr Menzies McVeigh saying that they have actioned it, but I would have actioned what I would have been asked to action by Ms Golightly, not something I would do off my own bat because I didn't know enough about the legal side of it or the program in the first place.
Okay, well, in any event, you knew that there'd been a request by Mr Jackson on the 6th of January 2017 for legal advice.
Yes, I did.
And you have no recollection of that advice being provided prior to you ceasing your acting role on the 16th of January 2017?
No, I don't.
Despite Mr Menzies McVeigh indicating it was a top priority?
I do not.
I suggest to you that's quite strange.
I'm sorry, I can't assist anymore.
Commissioner, that's the witness, the evidence of the witness.
Ms Hogan-Doran?
Just one question by way of clarification, Ms Kruse. You gave in your evidence some time ago that you said you had an assurance from the program area that there wasn't an issue with this at this time, referring to the issue of averaging. What were you referring, where was that assurance from?
The assurance was through the emails that I had received from Ms Golightly or through Karen Harfield at that early stage when I was acting. I think it was the 3rd or 4th of January, the week prior to my acting finishing. So there was a lot of information there through the media lines that we were preparing and provided responses to. Everything that was going back up through the program area for approval before it went to the media were all that same sort of sentiment or flow that what they had been doing was what they'd been doing for a long time, no more.
And before you were asked to answer questions for the Commission through the notice to give process, did you have any recollection of that assurance, or was it all just from having refreshed your memory from the documents?
Everything I've got is from having read the documents since I've been asked to provide evidence. It's been researching through documents.
When you finished in the acting role, did you have anything further to do with the OCI compliance program or what became known as the Robodebt scheme?
I went back to my substantive position, and in that position my role was to be a coordinator across the department for information to go up to the Minister's office, back from the Minister's office to the department, secretary back to the secretary. So whenever there was information that the Minister's office had asked for, we had to ensure that the program area or the legal area or the whatever area it was that was responsible to provide that information provided it and sent it up to the Minister in a timely manner. So that was my involvement through a coordination role.
Right, so just that I understand, so the Commission understands that evidence, that role as a coordinator across the department for information to go up and back through the Minister's office and to the department and the secretary, that would have included from time to time any issues concerning the OCI program?
Yes, because there was lots of requests on individuals that had debts that the Minister was looking for, and all of that information goes through the system that was managed by my division. So yes.
And how long did you continue? So is it right to say that was a conduit role?
Yes.
All right.
Yes.
How long did you continue in that role?
Until I left the department on the 4th of April 2017.
And where did you go to from there?
I went to the Prime Minister's office as the Senior Policy Advisor in the Cabinet Office on the 5th of April.
All right. No further questions.
Thank you.
May the witness be excused.
Yes, thanks, Ms Kruse, you're excused.
Do I just...
Commissioner, Mr Gregory and Ms Berry will take the balance of the evidence for today.
Yes, Mr Gregory.
Thank you, Commissioner. Before I call the next witness, I tender exhibits on the draft list numbered 5939 to 5953.
Yes, those items are admitted with the numbers they bear on the draft exhibit list.
Thank you, Commissioner. The next witness is Mr Andrew Asten, who is present.
Mr Asten, will you take an oath or an affirmation?
The oath, please.
Would you stand, please?
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr Gregory.
Thank you, Commissioner. Mr Asten, can you tell the Commission your full name, please?
Andrew Wilfred Asten.
And you were served with a notice to give a statement and produce documents, NTG-0157, dated 10 January 2023, and you produced a statement in response dated 25 January 2023, and a further notice to give a statement and produce documents, NTG-0198, dated 10 February 2023, and you produced a statement in response dated 15 February 2023.
Yes.
Correct? All right. And I think you have a bundle of material there before you, which is a compilation of various documents.
I brought one with me, and I'm comfortable with that based on the list that the solicitors assisting provided me with a few days ago, unless there's another one I should be referring to.
We'll just check your microphone, Mr Asten.
Okay, thanks. Thank you.
Okay, I understand you're not legally represented.
That's correct.
Okay. For a period of time,
Commissioner, in circumstances where Mr Asten is not legally represented, I'm not sure that the list that was sent some days before is the bundle that is, maybe that the bundle is broader. Is it broader at all?
Might be simpler if you take the Commission's bundle because it will have tab numbers that Mr Gregory can refer to. So wherever that's got to, can it be put in front of Mr Asten?
This one here?
oh, it may not be.
No, there's not names with my name.
I might just have a moment, Commissioner.
Commissioner, might I just inquire if you're, I've just heard there's a second statement. I don't think we've seen the second statement.
Jess, give him that. Mr Gregory, I'm just handing over mine, and have you got a copy of Mr Asten's second statement for Ms Hogan-Doran?
Yes, I'm instructed it's in the hearing book.
So, Mr Asten, some of the documents will relate to another witness, but there are some which are relevant to you, which you'll be taken to, no doubt.
Thank you, Commissioner.
Mr Asten, you practiced for a period of time as a solicitor before you commenced work at the Boston Consulting Group and other employers?
For a very brief period of time, that's correct.
How long?
I worked at Freehills, as it was then called, for 15 months, 8 months of which was as a graduate, non-admitted, and the balance as an admitted solicitor.
All right. And how long was your working career then before you became an advisor to Mr Alan Tudge?
I had a further, so I went to BCG for 3 months. I then took 11 months off to pursue study overseas. On returning from study, I continued at BCG for a period of 21 months. I then worked at the NBN for a period of approximately 12 months. And I commenced in the Minister's office after that.
All right, I'm not sure on the maths, but there was a couple of years between working as a solicitor and commencing as an advisor.
Yes, it would have been approximately 3 years.
Thank you. You performed the role of an advisor to Mr Tudge from March 2016 to August 2016, and then as his Chief of Staff from August 2016 to December 2017.
Yes, I believe that's correct.
And returned then to the Boston Consulting Group, where you are now a partner.
Correct.
Could you describe the role of an advisor in respect of your role and its relationship to the role of any other advisor in Mr Tudge's office?
Sure, and just for my clarification, are you asking me to reflect on the role of the advisor in the office, or my role as Chief of Staff in the office?
As an advisor in the office from March 2016 to August 2016.
Okay. So in the role of the advisor, my focus was primarily on welfare reform topics, technology and digital transformation investments that the department was making, and some service delivery topics, call centre waiting times, those sorts of topics. So my role in the Minister's office there was to be an engagement point between the Minister and the department to provide questions to the department that the Minister had and ensure the Minister had all the material he needed on which to make decisions on briefs that had come up from the department, but also to be prepared for parliamentary proceedings, question time, so on. I was also tasked with the Minister from time to time to assist with developing speeches or other material like that.
Was there an overlap between the topics of welfare reform, which were your responsibility, and technology and digital transformation?
Was there an overlap between those three topics?
Yes.
They were largely fairly discrete. So the digital transformation topics were primarily in regards to either MyGov or in relation to WIPIT, the Welfare Payment Infrastructure Transformation, which were two specific projects and capabilities. The welfare reform topic that I referred to was primarily a reform that the Minister was progressing in line with Minister Cash and also, I believe, Minister Tian at the time, to provide some reforms to the mutual obligations compliance framework to make that a fairer process, particularly for vulnerable recipients, and more difficult for people to take advantage of.
Who were the other advisors in the office during that period from March to August 2016?
So to the best of my recollection, there was John Deller, who was the Chief of Staff at that time. There was David Jancic. I think there was another advisor, Jared Newton. And I'm uncertain beyond that.
Was there another advisor who had an area of responsibility relating to social security payments or compliance?
Yes, there was. I'm sorry, I'm just trying to think back, because I wasn't responsible for the management of the office at the time, so my engagement would have been limited.
All right. Well, what about when you were Chief of Staff? Who were the advisors then?
So where I was going to, my best recollection is that the advisor who oversighted that topic at the time was David Jancic.
Yes.
And he would have continued that until Mark Wood commenced in the office.
And to your recollection, when did Mr Wood commence?
My memory is that it was in the second half of 2016. I have since been provided with Mark Wood's statement where he mentions October 2016, and I wouldn't have any evidence to the contrary.
By then you were the Chief of Staff?
That's correct.
And how did your role as Chief of Staff relate to the role of Mr Wood?
So as Chief of Staff, I had an HR type management role for the other staff in the office. I also had a role in reviewing written advice that advisors might provide through to the Minister before passing it on, sometimes asking for further information or further detail. Does that answer your question?
Yes, in that context, were you aware of, or did you see various briefs from the department to the Minister that would come through Mr Wood in the sense that they related to social security payments and compliance?
Yes.
And would you mark those briefs up in the course of providing a final advice role to the Minister?
I would only mark the briefs up if there was some additional commentary that I thought was required. It wasn't a case of doing it in every case as a matter of course. It was only where it was necessitated.
And would you mark the brief itself, or would you send an email or add a covering sheet? What was the scenario?
So it was all done in hard copy. The approach was the advisors would provide, we called it a blue. It was advice written on a piece of paper attached to the top of or covering the brief, and it was an advice or guidance to the Minister on key points to be aware of, and the advisor would write that. And in some cases, I would add a comment to those blues, although I would say that would not be the normal course. So the normal course that I would adopt would be if additional detail was needed, I would usually provide feedback to the advisor who would then amend the advice.
Right. You first became aware of the compliance scheme operated by the Department of Human Services in the latter half of 2016?
Yes, I believe in the later period of that half.
And that was in the context of information provided by the department and media generated through the Minister's office?
So my best recollection is that the first time I became aware of what is now known as the Robodebt program was in a conversation between Mark Wood and Rochelle Miller, where they were discussing some information that had come up from the department about an automated recovery scheme. That's my first recollection.
Do you recall articles in the Australian in early December?
That would have preceded those articles. So I think it was about November where that conversation was had.
Do you recall the articles?
In general, yes. Specifically, I couldn't name you a specific article, but in general, yes.
And your first awareness of the concept of averaging to assess income retrospectively for fortnightly periods and therefore create a debt or make an assessment of potential debt was in early January 2017, according to your statement?
That's correct.
From very late December 2016 and early January 2017, Minister Tudge was on leave and overseas and was replaced by Minister Porter, who stood in for him. You recall that period of time?
Yes.
And at that event, Minister Porter stepping in brought with it a lot of requests for information in the context of media about the compliance scheme. You recall that?
I do. My recollection is that I was also on leave for a period of that time, and so Mr Wood provided those briefings to Minister Porter, not myself.
And to your recollection, when were you on leave?
I'm honestly not certain. I haven't. I also didn't anticipate that question, so I haven't reviewed, travel receipts or other materials. I'd be happy to do so if that would assist the Commission. So I'm honestly not certain what weeks I would have been on leave.
In preparation for your evidence, have you sought copies of relevant documents from the Commonwealth which relate to the questions you were asked?
I requested documentation from the solicitors assisting.
Right.
Yes.
But what about from the Commonwealth, who holds documents that might be relevant to the questions you were asked?
No, I did not do that. I did not realise that was a step that I could take or should take.
What about your decision not to be legally represented? Were you aware that you could obtain legal representation?
Yes. Oh, I was informed of that about a week or maybe two ago, after I'd prepared the original statement or statement to give, the original statement. Prior to that, I was not aware that that was possible. I didn't think that it was a cost that the Commonwealth needed to bear. I was quite happy to assist the Commission to the best of my abilities.
Right. Albeit with documents that you had located or been provided with that had already been produced to the Commission, but not by reference to documents that might exist within the Commonwealth otherwise.
I'm sorry, I don't quite understand your question.
Your willingness to assist the Commission to the best of your abilities was obviously limited by the extent to which you had documents available to you, though.
Yes, and I made that very clear in my statements.
Yes. Do you recall paying attention to the media in respect of the department's online compliance program while you were on leave?
From time to time through that period, I would have reviewed the media briefs that were circulated by email, and so yes, I would have been aware of those media articles.
Is that because, despite being on leave, you had access to your work emails?
Correct.
All right. And were copied into all of the usual emails, including the media summaries?
I was copied into the media summaries, yes.
And received emails and from others who were at work?
I would have received other emails, yes. Yes.
All right. And have you reviewed those emails in the preparation for your evidence?
No, Counsel. I was not aware that I could request that documentation.
Well, if you turn to tab 9 in your bundle, there's the one before you, you should have Exhibit 4320, an email forward entitled How Centrelink Unleashed a Weapon of Math Destruction. Can you see that email?
Yes.
Now, you are the author of the second email in that sequence on Saturday, 7 January 2017, where you send an email to Ms Golightly, Mr Wood and Ms Miller. Hi Melissa, FYI below from the Minister. You see that?
Yes.
You forwarded it from your phone.
Yes.
And the email below it is an email from Mr Tudge to you We'll come to it shortly. But does that indicate that you were accessing relevant emails and staying on top of what was happening?
Yes.
Right. Were you back at work by this date?
I can't confirm that. I'm happy to review documentation if that would assist. I can't confirm that.
Let's talk about surrounding events rather than dates. What do you recall happening on the first day you returned to work?
So I recall that most of the office returned to Canberra from their home offices, wherever those may have been, and that the Minister was deeply engaged in meetings with the Secretary and other departmental officials.
So Mr. Tudge was back from leave?
Yes.
How long had he been back?
I believe he returned from, well, I believe I'm not certain of the Minister's travel dates, but I know that he returned to work almost immediately after he returned back into Australia.
And were you already at work when he returned?
I believe I returned on the same day or thereabouts on the... Yeah.
Okay. So either Monday the 9th or Tuesday the 10th, thereabouts?
Most likely.
Nonetheless, you were copied in or received this email from Mr. Tudge on the 7th, where he said to you, if that can be called down, PM sent me this one and has the clearest critique. Please forward this to Melissa. And there's a link to a Sydney Morning Herald article, how Centrelink unleashed a weapon of mass destruction. You can see that?
Yes.
The language of that email indicates that you and he discussed the topic before you received this.
I don't recall a conversation. We may have had one. I don't recall one. My interpretation of this is that this was providing context to the meetings which were to take place that week. He was asking me to forward this onto the department as context for the officials for the meetings that he was entering into that week as a matter of some urgency.
So you discussed the upcoming meetings that were to be held as a matter of some urgency?
He would have provided me with some instructions regarding the setting up those meetings or the timing of those meetings.
And so what you would expect was that there may be emails within the Commonwealth which relate to exchanges between you and Mr. Tudge in respect of the developing media situation and the need to set up meetings the following week on his return.
Potentially, although it would not have been typical for those communications to occur via email.
WhatsApp?
WhatsApp or text message or phone call would have been more likely for a logistical matter.
And to be clear, you haven't asked for any WhatsApp messages or text messages from the Commonwealth either?
I haven't retained those.
I understand that. But
And again, I was not aware that I could request documentation from the Commonwealth.
and so it follows that you haven't asked for it.
Yes.
Right. Undoubtedly, you read the article, which was the link sent to you by the Minister in the context of the PM sending it to him.
Yes.
You'll see it's behind tab 10, Exhibit 4321. And at the heart of the article, if we go to page ending _0001, so the second page of the document, you'll see that it raised two questions. One, the legality. You'll see in the fourth paragraph down what's important in this description. You see that? Is the humans charged with applying the law didn't issue debt notices unless they had evidence that a debt existed. To do so without evidence would be to break the law.
Yes, I can see that.
All right. Another of the criticisms appears in the third last paragraph, many of the automated systems. You see that?
Yes?
The concept of false estimates of debts because of the way in which they were calculated.
Yes, I see that.
That is, there was a mathematical difficulty with the allegation of income by notionally dividing or dividing income over fortnightly periods.
Yes, I can see that.
And you understood both of those criticisms as they were expressed in the article when you read it?
I would say that these raised questions,
Yes.
which were then discussed in detail with the department. I would not say that I fully understood the full meaning of these statements at the time.
Surely you understood at a basic level that if the government was demanding money from citizens and calling it debts, but they were not in fact debts, there might be some unlawfulness about that.
Yes.
Okay. Well, what did you advise the Minister in respect of this article and others which criticised the accuracy of debt calculations and raised questions of unlawfulness?
At the time, the Minister had requested in-depth briefings from the department, going through every aspect of the OCI.
Yes.
I did not attend all of those meetings. I attended a number of them. And so, in that sense, the Minister was relying first and foremost on the advice of the department in relation to these matters. I don't recall adding a particular personal perspective, given the expertise that sat within the department, the Secretary and the Chief Legal Officer at the time.
And were they the regular attendees in those meetings in that week?
Correct. The Secretary and the Chief Information Officer and the Chief Legal Officer, to the best of my recollection.
And let's put names
and the relevant Deputy Secretary, I should say.
Let's put names to the positions to be clear.
Sure. So Catherine Campbell, the Secretary, Gary Sterenberg, the Chief Information Officer, Melissa Golightly, the Deputy Secretary, and Annette Mussolino, the Chief Legal Officer.
But merely because they had expertise or purported to have expertise in the online compliance program, that doesn't mean that you lose your advisory role to the Minister, does it?
No.
No, your job is to assess the information the Minister's been given and to make sure that the wool's not being pulled over his eyes, for example.
Correct.
All right. Did you then trust what the department personnel were saying in respect of all of these questions of legality and accuracy?
I had a high degree of trust in the capability and professionalism of the senior public servants in those discussions.
But did you ever ask yourself or someone the question, how can I reconcile what is being told to the Minister by these people with the criticisms which appear in the media, such as this?
I think my perspective at the time was that the issues associated with the OCI were primarily issues associated with the implementation of the measure, that there were some significant problems associated with how it had been implemented, some significant gaps that needed to be remedied, and that was consistent with what I was hearing from the senior public servants.
Well, it may also be consistent with you accepting what you were told by the senior public servants. Are you saying you independently applied your mind to the questions raised in the media, or are you simply accepting what you've been told and you see no further scope for advice to the Minister?
I would say that the questions, for instance, regarding income averaging were raised at length. The department had clear and full answers to those questions. That income averaging had been used for a long time by governments of both colours, and that that use of income averaging was not a change as part of the OCI.
Yes, but did they say it was lawful? It's one thing to say we've always done this. It's another thing to say we've got advice that it's lawful to do it. You appreciate the distinction, yes.
The clear implication, I cannot recall whether it was stated, but the clear implication was that it was lawful as a long-standing practice.
Surely you would have asked the question yourself because of your advisory role.
I don't agree with that.
That is, you didn't ask.
I do not recall whether or not I asked that specific question.
Were you concerned, given a criticism like this, that the scheme may in fact be unlawful? Or were you concerned to see advice about it?
The department was very confident in their policy position, and the briefings to the Minister were very clear about the policy position, both from the Department of Human Services and the Department of Social Services.
Yes, policy is one matter, but law is another. Did you ever do the double check to say, have you got advice on this? Can I see it?
With respect, that is not within the ambit of my... firstly, no, I did not ask that question. And secondly, nor is it within the ambit of the Chief of Staff to a minister who was not the policy minister. That was not a question that was within the ambit or scope of my role.
What are the provisions of the social security legislation which permit this to occur?
So, thank you for the question, Commissioner. The understood scope for Minister Tudge's role and also for the advisors in his office was that this was a budget measure which had been decided on years previously, which implementation had already commenced on, and the responsibility was to address the implementation issues, significant as they were, associated with the measure.
But the implementation had only started a couple of months earlier in full, September 2016.
Yes.
And it evidently was creating havoc because you had complaints coming at a great rate and a lot of media. And you had the question of averaging's lawfulness being raised. It seems a pretty fundamental question. What permits this to occur? It wasn't asked by you, or?
I don't recall myself personally asking that question. The legality of questions like income averaging was raised, and the advice from the departments was clear around that.
And what was that advice? We've always done it.
That it's a long-standing practice, has been used by governments of both colours.
Well, as I said to another witness in another context, burglary is long-standing too.
Yes, Commissioner.
All right, thank you.
Did you advise your minister to ask the question to make sure he was on safe ground?
The minister was engaging in a greater detail of briefings than I was, including with the senior staff of the Social Services Department. I can't recall whether I asked that question or not.
Who were the senior staff at the Social Services Department?
So the secretary at the time was Finn Pratt, according to the best of my recollection. And I believe that Serena Wilson, I think, was one of the deputy secretaries with responsibility for the policy area, but I can't be certain of that.
Do you recall her attending meetings with the minister in that first week when he came back?
I recall her attending meetings with the minister. I couldn't say when they were.
Were they in January 2017?
I couldn't be certain, sorry.
How could you find out? What would record the meetings that you organised for the minister?
They were not necessarily meetings that I organised for the minister. The best record of them would probably be in the ministerial diary of Minister Tudge and or Minister Porter.
And how was that diary maintained?
Typically in Microsoft Outlook,
By whom?
the Minister's Executive Assistants.
And who was the Minister's Executive Assistant in January 2017?
I would have to check my records. Well, I would have to check the Commonwealth's records.
Okay. Well, can you turn to tab 11? It's Exhibit 3013. This was a letter received by the Minister's Office in December 2016. You recall that it came to the office?
My involvement with these letters was minimal. It was not standard practice for correspondence to cross the desk of the Chief of Staff in any great detail. And so I recall correspondence with ACOS being entered into, but I was not significantly involved in these letters or the preparation of the responses.
What about when ACOS attended the office of the Minister?
I reflected on that after reading Mr. Wood's statement. My best recollection is that I did not attend that meeting. I can't say for certain.
Do you recall that the Minister was upset that ACOS published information online or provided information which was published online soon after the meeting?
I recall something like that occurring at some point. I can't remember which policy topic. I can't confirm which policy topic it was in relation to. I don't recall that level of detail.
Well, point 1 in this letter raises the question of false notices of overpayment. That is, the system would likely be producing large numbers of inaccurate notices. And there are some consequences identified there. Did you provide the Minister any advice about how he would best handle the issues raised in terms of the accuracy of the notices and potentially false notices?
Sorry, just for clarity, Council, are you referring in regards to this particular letter, or are you talking about the issue more broadly?
Well, this letter raised, it would seem for the first time to your knowledge, the question of false notices of overpayment, as I understand your evidence. My question is, did you give the Minister advice about that topic?
No.
Did he ask for your advice?
No, as I mentioned earlier, my involvement with this letter was minimal. The normal course was for the relevant policy advisors to address items of correspondence and to do so directly with the department and to pass those through to the Minister for consideration.
A conduit role?
Sorry, say again?
A conduit role?
I'm sorry, I don't quite understand.
Well, your involvement is minimal, you say. Other people do the advising and the communications. You are a conduit for that?
So there was a difference between my involvement as regarding ministerial briefs from the department and correspondence from stakeholder groups and constituents. My involvement was greater in regards to ministerial briefs and lesser in regards to correspondence.
But you're not saying you had no awareness of this letter or the issues that it raised in the lead up to the Minister's meeting with ACOS?
I was generally aware of the letter. I do not believe that I had engaged with the detail of it.
Whose responsibility was it to engage with the detail of it?
Mark Wood as the relevant policy advisor.
You turn to the next document, 3065, you'll see the letter from ACOS 19 January 2017, which referred to the meeting the previous day. The second paragraph says, as reiterated during our meeting, ACOS calls for an immediate end to the automated debt recovery program. Did you provide advice to your Minister about whether that should be done in view of the concerns that they raised?
No, I don't believe I offered the Minister advice in regards to this letter.
Did he ask for advice to your knowledge, from anyone in the office about whether he should do that in view of those concerns?
I don't have knowledge as to what the Minister may have requested in relation to this letter. I would be speculating.
It is all you know is that he didn't ask you for advice.
That's all I recall.
Did you ever get any sense that there was a question about whether the program should be stopped, or that that was never really on the table?
So I believe I outlined in one of my statements that the very clear context in which the Minister's office was operating was an understanding that the Minister had responsibility purely for implementation, and there was no sense of any room or authorising environment where it was open to the Minister to pause, let alone cancel the program.
Even if it was unlawful?
Well, as I mentioned earlier, the advice that the ministers and the staff were operating on was that it was lawful, despite the commentary that was appearing in the media.
Well, the way you described that earlier was that that was an implied statement in the context of we've always done it like this, that sort of advice. Are you saying that it was more explicit? It is lawful? We have advice to that effect?
I don't recall a conversation that went beyond what I described earlier.
All right.
But it was a high level of, or a high degree of clarity that the departments had around it.
When you say they had a high degree of clarity around it, are you saying that they confidently said, we've been doing this for a long time?
Yes.
Okay. So a high degree of confidence rather than clarity about the legal issue?
Yes.
Surely, though, where questions are raised about whether this is legal, you can't just say, well, it's been decided and the minister's inherited it, we have to press on. That wouldn't be your advice, would it?
There may well have been conversations that I was not involved in.
Yes, but the point is you don't know about them unless you ask in the context of wanting to advise the minister about the best course to take. And it sounds as though you didn't ask about something and you were prepared to let it roll along despite the criticisms based on the assurance of the department.
I do not agree with that.
All right, well, did you do anything?
The issues associated with the legality of the system were discussed with the Secretary and with the Chief Legal Officer. They provided assurance to the Minister around the proper basis of the program. I may not recall all of the details that I would like to, but as the Minister's Chief of Staff and for the Minister, those questions were answered at the time.
But when you say assurance to the minister around the proper basis of the program, what you mean is the words you described earlier are, we've done this for a long time with both governments.
Those are the words that I recall.
Yes, all right. Which you appreciated as previously a practicing lawyer isn't a legal advice. It's got nothing to do with the law.
Once again, the legal advice was not the purview of the Minister's department. That was the purview of the Department for Social Services. They are the department with responsibility for the interpretation of legislation and the legality of policy measures.
Yes, I'll ask my question again. Which you appreciated as a previously practicing lawyer isn't legal advice. It's got nothing to do with the law.
The point that I'm making is that...
Please answer my question.
Sorry, what was your question?
You appreciated we've always done it this way, or words to that effect, is not legal advice.
I would have understood that that was not legal advice.
And yet that was the response to the question about whether it was lawful by the minister.
I cannot give you evidence as to what specific questions the minister asked. I do not recall that level of detail.
Well, you gave evidence that questions were asked about legality and that was the response. Are you saying you're not sure that questions were asked about the lawful basis of the scheme?
I remember that the questions around the lawfulness of income averaging were discussed.
That someone asked a question, do you mean?
I remember that they were discussed. I can't go any further than that without speculating.
But what was discussed? Whether it was lawful or whether the department had advice?
I remember that it was discussed whether income averaging was appropriate, was allowed. I don't think I can assist you any more than that.
So it may not have been a question, is this based on the legislation or not? Is this lawful? Do you have advice to that effect?
It may have been, but you're asking me for the details of verbal conversations had 6 years ago.
Yes, that's the point, is that it's very difficult for you to say, it seems, one way or the other, what was discussed with the minister.
I'm doing my best to assist the Commission.
I turn to the question of suicides which occurred in the course of the scheme and were said to be related to the scheme. That was a topic which came up on at least a couple of occasions. I know that you're nodding, but it's recorded. You have to give a verbal response.
Sorry, what was your question?
That was a topic which came up on at least a couple of occasions.
With the benefit of the documents that have been provided to me, I can remember 2 occasions on which that question came up.
Are you saying that without reference to the documents that you were provided, you did not have any independent recollection of deaths said to be related to the scheme?
I couldn't name you at other specific occasions.
Are you saying you couldn't recall that there were deaths related to the scheme as a broad question?
No, that's not what I'm saying.
Right, well, that was my question, so please answer it. Could you recall that there were deaths said to be associated with the scheme before you were provided with the documents?
Yes.
Okay. What's your best recollection of that?
So I remember that there were, among many instances of stories being relayed in the media of people going through a very tough time associated with the scheme, that there were a couple of examples where it was said that someone committed suicide associated with or around the same time as having interacted with the scheme or received a letter.
All right. What was the general response of the minister to those occasions?
My recollection is that the minister took them seriously. They were discussed in the minister's briefings with the secretary. My best recollection is that there were written materials that came up in relation to them, and certainly the minister was briefed in relation to them by the team.
And did that occur on every occasion?
I would anticipate so, but I can't confirm that.
You have access to documents related to the suicide of Reece Corso.
Yes.
You see that the minister asked for an investigation to confirm that the department had acted appropriately.
Sorry, can you take me to the relevant document on that?
You may not have the email before you. Do you recall that the minister asked for an investigation to ascertain that the department had acted appropriately?
Vaguely, but I wouldn't want to. I wouldn't want to state that as a fact without. Yeah.
You remember that the topic of Reece Causo's suicide, came to the minister's attention because it was in the media, the Saturday paper.
Yes, it was published in the Saturday paper, yes.
Right. And that prompted a response from Ms Miller and the minister about how to deal with this question that was in the media.
Yes.
Did you give the minister advice about how to respond to the journalist or what information should be given to the journalist?
Yes.
What was your advice to the minister in that respect?
My advice was as documented in the email that I would advise against going through the details in public.
All right, and what about the provision of information to the journalist to give another side to the story about the suggestion he actually had debts or something to that effect?
Well, I think the intent of the words that I wrote was one and the same thing.
Right. Well, this, if you turn to tab 14, Exhibit 4723, on the 13th of July, you received an email as the Chief of Staff from...
Just for clarity, this is in relation to a different matter?
It is, okay. Yes. You received an email from Jason Stott at the department.
Yes.
And it was copied into the Secretary and the Deputy Secretary, that is Ms Campbell and Ms Golightly, respectively, and a number of others.
Yes.
It indicated to you the potential significance of the suicide in question in the context of the scheme.
Yes.
The difference, or at least one difference in this particular case compared to Mr Causo's case, was that the department became aware of it before the media became aware of it. That's right?
Yes.
And what was your advice to the minister in that circumstance?
So my memory of this was that the minister was working from his electorate office that day, and so I was not in the same physical location as he was.
He was in Victoria?
Yeah, so I would have been most likely working from the Commonwealth Parliamentary Offices, which are in East Melbourne, and he would have been working in Wantirna. And my memory is that I called him mid-afternoon after having received not much of an update, but a little bit of an update from the department in the 2 o'clock departmental Chief of Staff meeting. And I effectively relayed the contents of the original escalation email to him.
Why not just forward the email then if that's all you're telling him?
I think it was the practice of the minister that he preferred to, sorry, let me take that back, come back a step. So for a matter like this, it was definitely the appropriate course to call him rather than send an email that he might not see or might not attend to that day.
You said that you were given information in a meeting at 2 o'clock that day. Who was the meeting with?
My memory is that it was not Jonathan Hudson, but someone acting in his role. I think the papers make an indication as to who that was. Potentially Jason Stott.
All right. You undoubtedly appreciated that the suggestion of suicide associated with the scheme was a potential media problem for your minister.
To be honest, that was not my first concern.
Was it any part of your concern?
It was not a significant factor in my mind.
What were the significant factors in your mind?
Providing assistance to the family.
And how would that be done?
The department was to contact them with a social worker and make inquiries as to what support they needed.
Was it any part of your concern that the allegation of debt in the particular circumstances or even discrepancy was correct?
Sorry, can you say that question again?
Was it any part of your concern that the allegation of a discrepancy against a person who committed suicide, or an allegation of debt against a person who committed suicide, was accurate?
I think any allegation that there was a suicide in relation to a government program was of great concern, yes.
And so what did you do in respect of that concern to assure yourself and inform the minister that the discrepancy was accurate or the debt was accurate?
So the first step was that I advised the minister or passed that information on from the department. I also, as you can see, asked the department for a further update
Yes.
at the end of the day. I have a memory that the minister and the secretary then discussed the matter in one of their subsequent in-depth weekly briefings, and I would anticipate that the matter had been fully explored in written briefings subsequent to this issue.
What did you ask for an update about?
As I said, my first concern was providing support to the family, and so I think that was what my immediate near-term update was in relation to.
And what do you mean when you say providing support for the family? What are you directing the department to do, or what are you asking the department to do?
So to be clear, I had no power to direct the department to do anything. The department indicated that they were making contact with a social worker, and I agreed that I thought that was important and a critical course of action.
And when you say the department, you mean Mr. Stott?
Yes.
And you're asking for an update about whether that's been organised, is that what you're asking?
My request was, could I please have an update end of day today after contact has been made with the sister? And so in that context, it seems reasonable to draw the implication that that was the primary matter, as well as any other updates.
That is, what is her attitude to the department after receiving some contact from the department? Is she likely to go to the media, or is that part of the update?
No, that is not part of the implication.
You're confident that that's not part of the updates you were seeking?
I'm very confident that was not part of what I intended in that communication.
Were you told by Mr. Stott that that was one of the topics they would raise with her?
I don't believe so.
All right. And insofar as any concern you had about the accuracy of the allegations of discrepancy or debts, you assumed that that was dealt with between the minister and the secretary in subsequent meetings or briefings?
As I mentioned in my statement, I was on leave for a period of time after this incident occurred. And
yes,
so,
what date was that again?
I have to refer to my statement. So I don't have the exact dates for my leave. I know that I was out of Victoria for the period of 22. I know that I was on leave for at least the period of 22 to 30 July, but my leave could have extended either side of that further.
And how do you know you were out of Victoria on those dates?
Flight itinerary.
That is from the following Saturday, the 22nd of July. You
Yes.
know that you were overseas.
I was in Australia, but
In Australia, but on a flight.
Yeah.
All right, well, what about in the week in between?
and so as I outlined in my statement, I don't have a specific recollection of other discussions that may have taken place during that week. I've been greatly assisted by the documents provided by the Commission for the date of the 14th of July, and that has significantly helped me refresh my memory of the events that took place that day. I made inquiries with Solicitors Assisting if there were other documentation available for that subsequent week that might be available to assist me, and that made inquiries, which I'm grateful for, but there were no further documents that were available. And so I haven't had a similar opportunity to refresh my memory with documents from that week.
That undoubtedly exist about where you were and what you were doing in the repository of the Commonwealth.
That may well be the case.
All right. So you clearly recall telephoning the minister. Did he express any concern about what happens if it hits the media?
I don't recall him.
Did he say we need an investigation on this like usual?
I recall him expressing great concern and wanting further information as the department made it available.
What sort of information?
As you can see in the email update from the department, it does not go into a particularly great level of detail. I remember that he was keen to understand more and understood that that would be forthcoming.
And would that come through you?
Well, it will come from the department. It can come in, I guess, two particular ways. One could be in the form of a written brief through the usual channels. Secondly, it could come directly via a briefing from the Secretary or relevant departmental officials.
Right, if you go to Exhibit 5947 behind tab 16A, you can see there's an update about the interaction with the sister of the deceased woman.
Yes.
And that doesn't answer any question about whether the suggestion that her death was related to the scheme in some way related to an accurate allegation of discrepancy or debt, does it?
No.
It might indicate that the woman is unlikely to go to the media because of contact made with her by the department, in the sense that she is satisfied she received a call as promised and said she now feels she has closure. You see that?
Yes.
So you can recall the specific telephone call with the minister, although not the specifics of what he asked for. What advice did you give after receiving that update to the minister?
I don't believe that I called the minister again after receiving this update. And given the time the update came in, my expectation is that it would have been held over until the following week for a more in-depth treatment.
That is, the urgency had gone out of it by 6 o'clock or 6:30 on the Friday night because of the response of the sister.
I don't believe there was anything else that needed to be done in the scope of a couple of hours.
Or the whole weekend?
Yes.
All right. And you have no recollection of the topic ever coming up again?
That's not correct.
When did it come up again?
As I outlined in my statement, I recall the Minister and the Secretary discussing it at one of their in-depth weekly briefings.
Is that because you were present?
I was present at many of those briefings, not all, but many.
Were you present at the one that you say the Minister and the Secretary discussed it?
Yes.
And that was the following week?
I cannot tell you what date that was.
Right. Did you make any notes of it?
No. Well, if I did, I do not have them now.
What did the Secretary tell the Minister about the circumstances in
I would be eager to assist the Commission. As I said in the statement, I do not have any further depth to that recollection.
Do you remember feeling a sense of relief that the sister wasn't going to the media?
No, that was not my concern.
Do you remember any information which related to your concern about whether the discrepancy was accurate or the debt was accurate?
From reading these papers, I remember that the key issue, or one of the key issues that was identified, was the absence of a vulnerability indicator on the recipient's file, and that was seen as a key process failing in this instance.
Well, what about the fact that there was an employment separation certificate on the file?
That issue may well have been discussed.
You didn't see that as a key failing on the part of the department?
All I'm saying is that I don't recall a discussion around that. I do recall the vulnerability or the absence of the vulnerability flag, which should have been there. I do remember that being called out as an issue.
But why was that significant if there was another document which indicated that there was no discrepancy? already on the file?
The vulnerability indicators are meant to be a red flag for all compliance activity. There to protect people who have a significant vulnerability of some kind. And so I think the absence of that was particularly troubling.
What did you do in respect of that particularly troubling feature?
As I outlined in my statement, I've exhausted the depth of that recollection.
You don't recall doing anything?
I do not recall any further depth.
Or any action, no matter how deep?
I am sure that there were further steps taken. I do not recall what they were.
You can't be sure that you took further steps then, can you?
I would anticipate that further steps were taken. I do not recall what they were.
Do you recall whether the Minister was the one who suggested the department engage PwC to conduct a review of the program?
I don't recall what led to the engagement of PwC. I don't have a memory of the Minister specifically asking for their engagement, and it would not have been the normal practice.
Did you advise the Minister that he should direct the department to engage external consultants in respect of the criticisms of the scheme?
No.
Did anyone, to your knowledge, in the department give that advice?
To the Minister?
Yes.
Not to my knowledge.
Did you attend a meeting on 19 April 2017 with representatives of PwC and Catherine Campbell and others?
Is there a document here that you want me to refer to?
Your recollection, we can start there.
From the papers that I have reviewed, there was a meeting which Mark Wood and I attended. I don't know about the other attendees that you mentioned, but it was in or about April of that year.
Who do you remember attending?
Mark Wood and myself.
And anybody else?
I don't recall anybody else attending.
You have a recollection of you two in a room, but nobody else in a room?
There were people from PwC there also.
Right. And if you turn to tab 20, do you recall this document being shown as part of the presentation?
Yes.
Okay. Exhibit 3895. Would you agree that the information presented by PwC to those present raised serious concerns about the accuracy of allegations of debt within the scheme?
Sorry, can you state your question again?
Would you agree that the information presented by PwC to those present raised serious concerns about the accuracy of allegations of debt in the scheme?
Your question makes it sound as if that was new information that we were hearing for the first time in the briefing from PwC, when that was not the case.
Had PwC provided information to your knowledge, that is to you?
No, all I'm saying is that the significant gaps associated with the implementation of the scheme and other matters were well understood.
All right, perhaps if you just stick with answering my question then.
Sure.
Rather than talking around it, would you agree that the information presented by PwC raised serious concerns about the accuracy of debts alleged within the scheme?
So I'm attempting to answer your question precisely. You say that they raised concerns. I'm saying that those concerns were already there.
Had PwC previously raised them, to your knowledge?
Not to my knowledge.
Okay, so was this the first occasion when PwC raised, to your knowledge, concerns about the accuracy of debts alleged within the scheme?
Yes.
What did you do with that information in respect of your advice to the Minister?
So this was a report to the department. My understanding was that the report was imminently being provided to the department, and the department was going to work those recommendations through the refinements to the OCI that it was in progress with, and would include those in the regular updates to the Minister and to the office about the changes they were making to the scheme.
So you didn't do anything particular about the information from PwC, the external consultant, that raised serious concerns about the accuracy of debts raised within the scheme?
It was part of the ongoing process of refining the OCI, which the department was deeply engaged with on a day-to-day basis.
And it seems which you had no engagement with apart from learning about it.
I'm sorry, I don't quite understand what you're asking.
Well, you're not giving evidence of being someone who was involved in the department dealing with information from PwC. You're giving evidence in your capacity as an advisor to the Minister. And I'm asking you what you did with the information that you had about the inaccuracy of debts, which was presented to you by the external consultant. What did you do?
So we were participating regularly in discussions with the Minister and with the department around the ongoing process of improvements to the OCI to address the gaps that I described earlier and the issues that needed to be worked through as part of the implementation. That was an ongoing process. This was one of many inputs into that process. And so can I say what I specifically did in relation to this one specific input? No, I don't recall that level of detail, but there were ongoing weekly, if not daily, discussions about what else needs to be done, what else is still in progress, when a new features or capability is going to be made available that make it easier for recipients to engage. It was an ongoing dynamic process. This was one of many inputs into that.
So there was lots of discussion about it and lots of information which came to the Minister about it.
And the Minister was regularly giving guidance to the department on what to prioritise and which features to improve.
All right. Did the Minister get this document then?
I can't recall that.
If we call out the top right-hand corner, that is the small writing above the dotted line, you can see the fourth bottom, or the fourth dot point from the bottom, data used for matching is not captured for this purpose and will continue to result in issues unless refined effectively. You understood that the data used for matching was the PAYG information provided by employers to the ATO?
I'm just trying to understand the context of this particular reference. So you're saying it's referring to PAYG data in this instance?
Yes, I'm asking if that's your understanding.
I couldn't say, just from that context there, I couldn't say whether it's referring to the PAYG information or the income reported to Centrelink.
All right. Well, what was to be done about the question of the data, whichever it was, that was used for matching when it wasn't captured for the purpose of matching?
And so there were substantial issues associated with the early rollout of the scheme.
Yes, I'm just asking about this point.
Okay. Sorry, so what's your question, sorry?
You said there was lots of information being conveyed and there were regular updates and the Minister gave direction to the department about what to do and what was happening in respect of these things. My question is, what was to be done about data which was used for matching, which was not captured for the purpose of data matching?
You're asking me about what was to be done about the refinement of PAYG data used for the purposes of data matching?
I'm asking you what you did with this information in the context of the evidence that you gave about how information was treated by you and the Minister.
With respect, I think you're assuming a much greater role for me in this scheme than what I played.
What is your purpose in going to the meeting, if not to be informed about these matters so you can advise the Minister?
Your question goes to the heart of the data analytics at the core of the OCI.
No, it just goes to a dot point on a document at a presentation you were given by an external consultant in your capacity as an advisor to the minister. That's all I'm asking. What did you do with it?
So as I said, this was one input of many. It was a report to the department. The department was working through an ongoing series of refinements and regularly engaging with the minister about the progress and detail of those refinements. And so my involvement in respect of this was those ongoing discussions which incorporated this as a key input.
What does that mean? What happened about this point? People talked about it. Is that the effect of your answer?
I don't recall what changes were made in the OCI as a result of individual recommendations made by individual bodies.
All right. We'll move then to your understanding of the report. You said a report was being prepared, I think, which was to be provided. What do you recall on that topic?
I don't recall receiving a report across my desk in relation to the PwC work.
Okay. Did you ask where it was, given you knew it was being prepared?
I don't believe so, no.
Why is that?
I don't know.
You're the Chief of Staff. You know a report's being prepared by an independent consultant. There's regular weekly meetings or frequent meetings, updating information for the department, for the minister, so the implementation issues, as you describe them, can be developed. And in that context, a report is being generated as a part of that process. That's your understanding?
The report was being prepared for the department. It would not be the usual practice for ministerial advisors to be requesting engaging with reports prepared by consultants in detail. The approach, long-standing, is to engage with the department as the core source of advice, and the department may from time to time engage consultants to support them.
Yes, perhaps my question was unclear. All of that might be accepted.
Yes.
But the point of the department engaging PwC as an external consultant was so that it could provide advice on things that the minister wanted to know about.
That presumes that the minister requested the report.
I'm not suggesting that. I'm suggesting that the minister wanted to know about difficulties with implementation, what the issues were and how they were to be resolved. Do I understand your evidence correctly?
Yes.
Okay. Surely the most accurate conveyor of information would be the report prepared at the end of this process. Or do you disagree with that proposition?
One thing that may assist, as you indicated earlier, this meeting took place in mid-April, and it was conducted on a fact base from the first 6 months of the program. By the time mid-April had arrived, a significant number of changes had already been made to the program. And so the currency of many of these findings would have been less by that stage. And so that may go some way to contextualising where this sat in the processes for the department and briefing the minister.
Surely the report produced by PwC at the end of the process would be the best guide to the implementation difficulties that remained and what should be done about them.
I don't agree with that.
You think they produced a report or were working towards a report at the end which was not going to be as much help as documents like this?
My memory of the time is that this was one input of many. It was an outside-in perspective, and that's helpful to the work of the department, but it's certainly not a decisive or authoritative view of the whole situation.
Hence the report which is produced at the end of the analysis.
So what I'm saying is the report would not have been an authoritative or complete view of the whole situation.
Why is that the case again?
It was an outside-in perspective based on information which was, by this time, somewhat dated. I don't think this was ever seen as a report that was, or as an analytical effort that was comprehensive or covered the field.
Why do you say that? What information did you have on which you came to that view?
I think at the time, there were other inputs also underway, such as the work around the Ombudsman's report, the substantial and in-depth briefings that the ministers were engaged in, which also provided a significant depth of information. And so I think this was viewed as one input among many that had significant further detail.
You're not suggesting that the Ombudsman was a substitute for PwC?
I'm suggesting that there were a number of inputs of information and that this was one of those.
Yes. You're not saying it's irrelevant?
No, I'm not saying this is relevant.
You're not suggesting the department didn't have to pay for it?
No, I'm sure the department did pay for it.
All right. And you are involved in briefings, at least on one occasion, but perhaps others, from PwC about things they find as they go?
I believe this was the only time that I interacted with the PwC engagement.
You understood a report was being prepared by PwC in respect of their analysis?
Yes.
And you had no interest in seeing the final report?
I don't accept that.
What interest did you express then about seeing the final report?
I would have anticipated that if the recommendations of this report had material potential impact for improving the OCI scheme, it would have come up from the department in a brief, which would have been the appropriate course of action.
Yes, well that is the thinking of the department. I asked you about your thinking. What did you do? Given you had interest in seeing the report, did you ask for it?
You were asking about one meeting that occurred 5.5 years ago. I don't recall my state of mind around that meeting.
No, I'm not asking you about one meeting 5.5 years ago, Mr. Asten, and you know that very well. I'm asking you about your interest in the report produced by PwC, which you anticipated would flow following this meeting at some point. You say you were interested in it, and I'm asking you, what did you do to express your interest?
I don't recall steps that I took subsequent to that meeting.
You see, Mr. Asten, one view is that you were well aware that the report would describe deep flaws in the scheme, implementation as you might characterise them, which really indicated that the scheme should be stopped. It was so deeply flawed. And you did not want to see it.
I completely reject that.
All right. What about the Minister? Did you tell him about the flaws in the scheme that you learned about on this day?
As I said, much of that information in this report was not new. It was well canvassed by the time we arrived at April. I probably did discuss this with him, but I can't recall specifically that I did.
But this is not subjects that the Ombudsman would be covering, are they?
I haven't had enough time to review the material or do a comparative analysis with what was in the Ombudsman's report.
These are not subjects that the department could speak authoritatively to, are they? Because they engage someone else to do it.
I don't think that's necessarily true. Often departments will engage outside consultants for an alternate perspective or verification.
You turn then to tab 24, Thursday 27 April 2017. You're referred to in the first line as being the person who gave feedback from the presentation. And there are a series of dot points which ask questions. What are the top 5 reasons for drop-offs? How will these be addressed? How will MyGov notifications be supported by other communications? You refer to the vulnerable filter. What is likely to be lost from the financial year 10-11? Updates to roadmap to make more specific. You see that?
Yes, I see it.
Those are questions you asked following a previous presentation.
According to this email, yes, but I can't. I can't confirm or deny that.
What do you know of the Minister's request to Ms Campbell to engage Data 61?
So I remember that the Minister discussed the appointment of Data 61 with the Secretary and thought it was potentially a valuable exercise to have their data science expertise brought to bear.
Was that on your advice?
No, I suspect it would have been on the Secretary. Well, I don't know if it was on departmental advice or not, so I'll withdraw that.
Do you know if it was on your advice?
I don't think it was on my advice.
Did you ever see a report?
I was reflecting hard on this. I don't recall seeing a report. I can't exclude the possibility that I did, but I don't remember receiving a report from Data 61.
There was very significant scrutiny on the scheme from a number of angles. Surely you would have been concerned to ensure that the Minister's request that the department engage Data 61 to produce a report was followed through.
As I outlined in my statement, my role as Chief of Staff had many elements. The OCI was but one part of that role, and
I understand you were very busy. My question is not about what other things you were busy with. My question is, surely you were concerned to ensure the department followed through on the Minister's request.
and
Was that part of your role?
yes, and
Okay, what did you do about the Data 61 request?
well, the Minister made the request to the Secretary. The Secretary had appointed Data 61, and I remember that subsequent to that, weeks or months later, the Secretary advised the Minister of the outcomes of the work, and the Minister was satisfied to move on.
The advice I think that you are describing is behind tab 27A, Exhibit 5952. You see that?
27A. So the email,
Yes.
so this is the first time I've seen this.
All right, well then perhaps if you go to tab
Yes.
28, Exhibit 4760.
Yes, I can see that.
Is that what you're referring to in your earlier evidence?
So I had seen this one approximately 48 hours ago, maybe 3 days ago. What's behind tab 27 is new to me, but I understand it.
Is Exhibit 4760 behind tab 28 what you are referring to in your evidence?
Just earlier when I discussed that the Secretary had provided an update to the Minister, I remember that the Minister and the Secretary also had a verbal discussion around the Data 61.
Is that because you were present?
Yes.
Right. Did it follow this email?
I don't recall the detail of the discussion.
Is this the only document you saw in respect of Data 61's engagement?
I don't recall receiving any other document. I can't exclude the possibility that I did, but I don't recall receiving any other document.
And are you saying the Minister was satisfied with what was contained in this document and the conversation, the contents of which you cannot recall, as being a sufficient answer to his direction to engage them to report?
That would presume that the Minister didn't receive any other documentation. I can't confirm with you whether or not that was the case. And I would anticipate that the substantive report from Data 61, if it had come up, it may well have been in a ministerial brief that the Commission may have access to, but I don't have an independent memory of that document coming up.
All right. Did you have any knowledge that there was a suggestion by the department that there was an error in Data 61's draft report?
I remember that there was a sense that there were limitations or some shortcomings or some gaps. I don't remember what those were.
Did you have a sense that that was why the Minister was satisfied with less information than the full report?
I'd be speculating if I confirmed that.
No further questions.
Ms Hogan-Doran,
No questions, Commissioner.
did you have anything, Ms Findlay?
No, I don't. Thank you, Commissioner.
All right. Do you wish Mr Asten excused?
I do, yes, thank you.
Thanks, Mr Asten, you're excused. Now, do you want to attempt Mr Wood? What do you want to do?
Yes, I would like to attempt it.
Okay, we better take a 5-minute break because the transcribers will need, I think, to have a little rest.
All rise. The Commission stands adjourned for a short break. Commission is now in session. Please be seated.
We've got Mr Wood.
Yes, Mr Wood is
Mr
present.
Wood, will you take an oath or an affirmation?
An oath, please, Commissioner.
Would you answer that, please?
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr Gregory.
Can you tell the Commission your full name, please, Mr Wood?
Mark Terence Wood.
And you are currently a Senior Policy Advisor in the Office of the Leader of the Opposition, the Honourable Peter Dutton MP.
I am, yes.
And you've held that role since July 2022.
That's correct.
You were served with a notice to give a statement and produce documents, NTG-0158, dated 10 January 2023, and you produced two statements in response, the first dated 25 January 2023 and the second dated 24 February 2023.
Yes, that's right.
All right. And are the statements true and correct?
They are.
The period of time relevant to the scope of this inquiry relates to your time as an advisor, or primarily to your time as an advisor to then Minister for the Department of Human Services, Alan Tudge, in 2016-2017.
Yes, that's right.
During that period of time, you became aware of the department's online compliance intervention program by which it alleged and recovered debts from former recipients of
Yes, I did.
payments. That is, they might be current recipients, but in respect of payments previously received.
Yes.
When did you first become aware of the scheme?
I recollect late November, early December of 2016.
And was that initially in the context of information from the department and media promoted from the Minister's office?
That's correct, yes.
And then later in December, did you become aware of public criticism of the scheme?
Yes, I did.
And were you on the ground, as it were, when Minister Tudge was on leave and Minister Porter was filling in?
I was.
Did you meet with Minister Porter during that period in very late December and early January before Minister Tudge returned?
I don't recall meeting him in person, no.
Did you have telephone calls with him?
Yes, I did.
And what do you recall of when they started?
I recollect it starting in just before Christmas. It might have been around the 21st, 2nd or 3rd of December, and then continuing on after the Christmas break, early in the new year.
Certainly the media, or the criticism of the scheme and a number of aspects of it, gained increased media attention in the first week of January 2017.
That's right.
And that led to Minister Porter appearing on Radio National, the 7:30 report, and giving interviews and the like.
That's correct, yes.
What do you recall of the nature of Minister Porter's requests for information to which you were a party on a telephone call or the only recipient?
I recollect Minister Porter wanting initially a very, what we would call a high level. What is the program? What is it about? How is it functioning? What is it doing? And what is the basis for these criticisms?
And how did you set about providing answers to him for his questions?
I recall at various times going to members of the Department of Human Services on a verbal approach, and going back in a verbal approach to the Minister.
And did you speak with him directly or to his advisors?
A combination.
Who were your primary contact points in the department as sources of information?
Probably Deputy Secretary Melissa Golightly, the Chief Counsel Annette Musolino, and a number of others over a number of times, and there was such a high level of people I spoke to. Jonathan Hudson was there at various times. Barry, whose last name escapes me at the minute, I'm sorry,
Jackson.
Counsel, that's it, and others.
What information did you receive from the department about any legal criticisms that were raised in the media? That is, if you did at all.
None specifically.
Did you ask the question?
No, I did not.
Why is that?
It did not occur to me to ask the question.
In advance of Minister Porter's appearance on the 7:30 report on 4 January 2017, there was knowledge provided by the 7:30 report, or persons from the 7:30 report, that there was to be a legal criticism of the scheme from a representative of Victoria Legal Aid. You recall that?
At the time, no, but I do now, having read the notes of preparation for today.
You've seen the various documents.
I have.
I think in the smaller folder to your right, there are some exhibits which relate to this. I take you to tab 3. It is exhibit 5938, capital B. You have that? Yes. The last email in the sequence is from Melissa Golightly to an email address described as media, Sue Kruse, Barry Jackson and Karen Harfield, and copied to others, about 2:12 on the afternoon of 4 January 2017.
I see that, yes.
Thank you. And further down the page, you see the email from Ms Golightly to the media email address, copied to others, and it refers to our Minister's office has requested background information for Minister Porter regarding 2 case studies featured on ABC's 7:30 report tonight. You can see that?
I see that, yes.
All right. Now, is the reference to our Minister's office in fact a reference to you?
It may be, but I can't be certain.
Were there other people ordinarily employed in the office back to work to deal with the issues that were raised in that first week of January?
From a media perspective, yes. So because it was in preparation for a media activity of the standing minister, the media team would be involved in the discussions with the network or the journalist and what was therefore required from the department.
All right. If we go to the page ending .0311, this is earlier in the email sequence. At about 10:18 in the morning, you'll see an email from Sarah Kernow to Amy Jones, copied to Pat McGrath, and you appreciate who Ms Kernow and Mr McGrath are in respect of the 7:30 report.
Yes. And
the information provided there about partway down, thank you, you'll see that what is described as the issues which are raised for the report related to the question of income being averaged retrospectively, and that what was intended to be raised with the Minister was lawyer Dan Nicholson argues the relevant benefit entitlements are to be calculated fortnightly under social security law, not on the basis of average fortnightly income, brackets derived from total annual income. So the assumptions built into the data matching system are in this respect inconsistent with social security law. Just pause there. You later were copied into the email trail, as you'll see, at 1:27 p.m. when Ms Jones forwarded the email to you, Sarah Bland and Kevin Donnellan, and Cheryl G. William.
Yes.
And Mr Donnellan and Ms G. William are the advisors or staff from Minister Porter's office.
Correct.
And Sarah Bland was an advisor in Minister Tudge's office.
That is right.
All right. There was or you may not know this, or you may know this, but were you involved in a telephone call with Minister Porter and persons from the Department of Human Services that afternoon in preparation for the interview on the 7:30 report?
I don't specifically recall that, no.
Do you recall, as a result of this legal question which was raised, or legal criticism from Dan Nicholson, which featured on the program and of which the department had advance notice, that Minister Porter asked any questions about the legal underpinnings of the scheme, to your knowledge?
To my knowledge, I don't recall that, no.
That is, you don't recall any occasion where you alone or you with others were on a telephone call or a face-to-face conversation with Minister Porter during this period when he asked a question along the lines of, have you got advice about this, or words to that effect?
That is correct, I do not recall that.
And you indicate that you yourself never asked the department the question?
That is true, I did not.
Did anyone else in your office raise the question of the lawfulness in your context? In your company, or to your knowledge?
Not to my knowledge, no.
And did you ever advise the Minister that the question should be asked?
No, I did not.
There was another media article which specifically raised the question of lawfulness, and it was the article authored by Peter Martin and published in the Sydney Morning Herald on, I think, 6 or 7 January 2017. Did that prompt any reflection on the legal underpinnings of the scheme within the Minister's office?
No, it did not.
Mr Wood, those emails, that email chain, the people from the 7:30 report articulated the question quite neatly. The lawyer's argument was that benefit entitlements were to be calculated fortnightly under Social Security law, not on the basis of averaged fortnightly income derived from total annual income, so that the assumptions in the system were inconsistent with the Social Security law. That encapsulates neatly what the problem was with this. Right there and then, there's the legal question. And nobody ever wants to get it answered?
It appears not, Commissioner, no.
This was an area which was your responsibility in terms of advice to the Minister, is that right?
One of them, yes.
So was it the fact that you weren't interested in knowing the answer to the question?
I hadn't turned my mind to asking that specific question, no.
What do you think now, with the benefit of hindsight, that it would take for you to turn your mind to it, if not that?
With the benefit of hindsight, I probably would have been more specific at getting more depth and understanding of the detail that was coming up in those questions, where it says we've been doing this for a long time and we're operating under the system, and legal opinions are being offered. It would be, well, what is it that we're doing here that is legal?
But surely all it would take for you, from your perspective, was to say, how is that question going to be answered, and what do I need to tell Minister Porter or his advisors?
Not necessarily in this instance. With a number of people advising Minister Porter, who was the acting minister and of a legal background, would satisfy himself that he has information at his disposal, generally, and if any minister would want more information, we would seek more information.
Yes, I understand all of that. But you have notification of the question in advance. We know that the Minister is after what assistance or information can be provided from the department in preparation for his media appearances.
Yes.
Are you saying that you weren't copied into any information which answered that question to prepare him for his interview?
I don't believe so, no.
And it didn't cross your mind to ensure the Minister had an answer to it?
No, it did not. It was mostly a media process of the briefing, and Minister Porter would be relying on the best advice that the media team would give him how to answer particular questions. And if there was a more in-depth policy area that he required, then I would seek out further information if instructed, or the Minister's own staff could do that.
What did you understand, assuming that you made some inquiries about this topic, in the respect of the role played by averaging YG income in the assessment of actual fortnightly income.
Sorry, what did I understand it to mean, or?
Yes.
That in the absence of any other detail or enough detail from the recipient, that the department, using income information from the AETO, would make an average estimate of what the person earned over that period.
You understood there were criticisms of that process in the media?
Yes.
Because it was apt to produce an inaccurate estimate.
As was reported, yes.
And surely the department liaison officers to whom you had access in the Minister's office would confirm that for you?
If I had asked, yes.
What about persons within the department? If you had asked them, would they have been able to answer that question for you?
I recall having conversations about that very topic, and at various times it was made clear to me that this was a long-standing practice, and rightly or wrongly, I did not dig any further than that.
But whether that was the way the department had always done it or not, putting aside the accuracy of that statement or the correctness of that statement, surely you were concerned that if it was producing inaccurate notional earnings and therefore inaccurate assumed debts, that was something which should be corrected or stopped.
That is correct. Yes.
So what did you do to assuage your concerns, as it were, about the fact that there might be inaccurate debts being raised by the system using the data in that way?
At that period of time, over a Christmas period, Department of Human Services normally stops compliance activity or sending debt notices to customers over the Christmas and New Year period, and that generally recommenced in mid-January or thereabouts. I don't remember the exact position, but I knew that we were going into multiple iterations of looking at the system and how it could be improved and how it could be made less bad, I suppose is the term, and at that period we would start those processes soon to make those fixes.
I'd ask if Exhibit 5816 could be placed on the screen. SKR.001.001.0272. I understand this is not in either bundle before you. That's why I've asked for it to be placed on the screen. But this is an email for January 2017, and it's from Ms. Golightly to a number of people, including you. And it refers to a telecom earlier today. Do you remember that telephone call?
Not specifically, no.
It copies in the acting secretary, Mr. Jackson. There's someone from the secretary's office, Sue Kruse, an acting deputy secretary at the time, and Karen Harfield. Do you see that?
Mm-hmm. Yes, I do.
Does that refresh your memory about who you were talking to on that day?
Not specifically, no, I'm sorry. There was, with Minister Porter, we had lots of conversations around that time, so I can't declare specifically that one, but yes.
In any event, it attributes to a discussion earlier that day an explanation, a question of how the algorithm was used and an explanation of how long it's been in place.
Yes.
Which is said to be something that the Minister wanted before 3:30. The explanation, if you go to the second paragraph, indicates that it requires, or rather refers to assessing / applying income when it is first earned, derived or received. However, the practicality is that's not always known. The choice would be to ignore it or apply it in the best way available. Did that cause you any concern that the department was proceeding where it acknowledged that it wouldn't know when the income was first earned, derived or received under the Act?
It does cause me concern, yes.
That is, it causes you concern now, or?
Now, I don't recall having read that at the time.
Do you recall a staffer of another parliamentarian raising, with Miss Miller at any rate, that she'd received a debt notice, having had income when she was a student, averaged?
No, I don't, Commissioner.
Okay.
Do you recall engaging, or ACOS engaging with the Minister's office both by sending letters and by attending a meeting with the Minister in January?
Yes, I do.
And they raised concerns about the accuracy of the letters that were being sent.
They did.
What advice did you give to the Minister about that question?
I don't recall specific advice I'd given to the Minister at the time. I think the Minister Tudge was on leave, and as the advice had come up via correspondence from ACOS, I'm not saying I had not had verbal conversations, but when it came in specific written request for information, the usual practice was the Department of Human Services would prepare a response on behalf or for the Minister that would come to me, who I would then read through and match whether or not the information request met, or the responses met the request, and then pass it to the Minister for signature and sending out.
All right. I might take you to the letters. The first is behind tab 11 in the bundle, Exhibit 3013. This is the letter from ACOS to then Minister Tudge, 21 December 2016. That was the first notice you had of their engagement with the Minister.
Sorry, would you repeat the question?
This was the first notice of any interest by ACOS that you understood or became aware of?
No, I recall earlier in December I'd had exchanges verbally and via email with members of ACOS, yes.
Okay, so this came as no surprise.
That's correct.
Dot point 1 is unambiguous in its assertions. It indicated that the system produces false notices of overpayment. It was a serious problem, likely to be producing large numbers of inaccurate notices, wasting recipients and the department's time and resources, as well as causing much unnecessary stress and anxiety among recipients. Did you give the Minister any advice about what he should do in respect of that type of complaint?
I don't recall, without seeing the response generated from the department, that would address that outcome, and I would have read that at the time and drawn to his attention if I thought necessary.
Well, tab 12, Exhibit 3065, a letter dated 19 January 2017. It refers to a meeting yesterday to discuss the automated debt recovery action. You'll see in the second paragraph, as reiterated during our meeting, ACOS calls for an immediate end to the automated debt recovery program. And it continues, was the Minister interested in pausing the debt recovery program to permit that round table to proceed with various stakeholders?
I don't recall the Minister ever making that assessment to me, no.
And you never advised him to pause the program?
At about this time, all debt collection activity from Human Services was on pause over a Christmas period, and we had met on Minister Tudge's return to make refinements to the system to make sure that when it did kick off again, that it was as good as it could have been.
When you say as good as it could have been, do you mean that it addressed the dot points at the bottom of the page? If we take them in sequence, the reversal of the onus of proof, did it ever address that, or was that something that was beyond the reach of what might have been as good as it could have been?
It was my understanding of that, and I recall advice coming up as late as March that that onus of proof or reversal thereof was no different. A slight change in it, but no different than the onus had been previously in existence. But it did not address that specifically in the iterations we were looking at that time, no.
rather than accept the fundamental premise of the scheme introducing a reversal of the onus of proof, the department have simply asserted that it had always been that way.
That's correct.
How did you reconcile those two positions? You've got perhaps one of the peak bodies in Australia saying that this scheme involves a reversal of the onus of proof.
Yes.
And the department saying, no, we've always done it this way. The peak body's been involved for more than just this scheme.
I took, in good faith and at face value, the department that were sort of professionals and experts that had been in this space for quite a long period of time, much longer than me, and I did not dig further onto, the onus of burden of proof or the onus being changed.
Did no one take ACOS's repeated complaints on this topic at face value?
It seems not.
And you didn't give any advice to the Minister to investigate whether there had in fact been a change, as ACOS said there had been?
No, I did not.
Did you get the impression from the Minister that really he just intended that this scheme would continue and as many of the complaints that could be addressed would be addressed, but otherwise nothing was going to stop it?
That was never, I did never heard that being articulated. No, that's not what I recall. I do recall, as you said, was making ongoing and constant improvements to the system.
Was there any point where you thought, gained the impression that the Minister was considering pausing the scheme to address some of the fundamental concerns about legality and accuracy that have been raised by many people?
Not that I recall, no.
Do you recall attending a meeting with Mr Asten and others on 19 April 2017 where PwC gave an update on their review of the online compliance intervention program?
No, I do not recall that at all.
Do you recall the department engaged PwC to conduct a review of the program?
I recall there was engagement of some of them, yes. And when I say some of them, I mean some external parties to do work on behalf of or for the department or the Minister.
Do you particularly recall PwC?
Yes, I recall PwC being one of them, yes.
And do you recall Data 61 being another?
Yes, I do.
We might deal with those in reverse order. What do you recall of Data 61's engagement?
I recollect that the Minister had put forward to the Secretary, and I don't know how I'm aware of that, as whether it was at the time or whatever, that Data 61 to be engaged to look at some of the data analytics that were sitting underneath the online compliance system, having the system run from sort of earlier in the year, but causing the issues that it had caused towards the end of the year, that the Minister was wanting Data 61 to see what insights they could provide either to the Minister or to the department, and I can't recall whether it was to either or both.
The Minister was taking, at this time, a keen interest in what the department was doing to address concerns which were raised publicly.
That's correct.
And undoubtedly would have wanted to know what Data 61 said about
That's right.
the concerns.
Yes.
Do you recall following up on the Minister's request or direction to the department to get Data 61 involved?
I don't recall doing that at the time, but in preparation for today, yes, I do recall some instances where indirectly the Minister had sought, so I think through the Chief of Staff, to find out information on where it was up to, that a report should be being readied for the department, and to seek out sort of some high-level information of that report.
The occasion you may be referring to is 17 February 2017. If you turn to tab 27A in your bundle, Exhibit 5952, Is that the high-level information that you're referring to?
That is indeed, yes.
Doesn't really tell you very much though, does it?
It's very scant.
Did you advise the Minister to get a copy of the report or the notes or the drafts of what Data 61 had provided?
I don't recall or can read here specifically seeking that, but given the Minister had specifically asked for some information from the Chief of Staff, we'd specifically asked the Deputy Secretary for information, it is highly probable, if not impossible, to believe that a report isn't developed or delivered or produced for the Minister.
Sorry, do I understand your evidence to be that given the Minister's request, you find it difficult to imagine circumstances in which the department did not provide the report?
That's correct, yes.
Or something more than this?
That's right, yes.
Are you aware of anything more than what is contained in Exhibit 5952 being provided to the Minister?
Only in preparation for today, yes.
And what is that?
A document that purports to be from Data 61 regarding insights into the OCI system.
All right. Is that behind tab 27? Exhibit 4759. Perhaps if we could have exhibit 4759 on the screen. CTH.3001.0051.1320. Is that the document that you say went to the Minister?
I'm sorry, I don't recall. This is, I mean, I only saw this document for the first time. I recall seeing it for the first time in preparation for today, but I don't recall specifically which document going to the Minister, no.
All right. Sorry, my earlier question was whether you were aware of anything more than what was contained in that brief email going to the Minister. Are you aware of whether this document went to the Minister?
I'm not aware of whether it did or not, no, I'm sorry.
All right. And your recollection today is that the first time that you hadn't seen it previously?
That's correct. And I know, and I believe this because a document marked sensitive is not something I would normally have dealt with in the Minister's office, and had it been marked sensitive, it would have stuck in my mind as something that was probably important and sensitive.
Well, then we go to PwC. What do you recall of their involvement?
At the time, I recall the Minister seeking lots of people to do reviews and the department seeking reviews to give us understanding of where more improvements could be made in the system. And I recall that PwC was one of those organisations or groups that were doing that.
I'll take you to tab 18 in your bundle, Exhibit 5948, pwc.1007.1013.7368. This is an email arranging a meeting for a discussion with PwC on initial findings and recommendations for the Compliance Process Improvement Review engagement, and it includes you as a required attendee.
I see that, yes.
And this is 19 April. Do you recall attending a meeting with PwC?
Not specifically, no.
In Sydney, at the PwC offices?
No.
Do you recall attending any meetings with representatives of PwC?
No, I do not, I'm afraid.
Right. If I take you to tab 19, exhibit 3894, PwC.1007.1003.3467.
Commissioner, just before my friend turns to that, it's Sydney Avenue Forest, not Sydney as in
sorry.
city.
Thank you. Or in Canberra?
Doesn't change my, no, sorry, no, it does not.
Do you recall any of those names? Frank Van Hagen, Terry Webber, Shane West, Tybo, Lee Hunter?
No, I do not.
All right. Can I take you to tab 20, exhibit 3895? It's a document entitled Insights from Current State Assessment, and it has 3 columns with progressively smaller font. Do you recall seeing a document like that before?
No, I do not.
Do you remember generally that the review, the material provided in the review by PwC was well, it identified serious flaws in the compliance program?
I'm afraid I don't recall that at all. I don't recall the PwC document at all.
Do you recall at least the awareness that PwC was going to prepare a report based on their review of the compliance system?
Yes, I recall PwC being engaged by someone to actually look at what, the system, yes.
And provide a report on...
That would, normal case, yes.
Do you recall ever seeing a report?
No, I don't.
Do you recall ever being told that it was near completion?
No, I do not.
Do you recall asking for it?
No, I do not.
Given the Minister's keen interest in all things compliance related, can you give any insight as to why you never saw a final report or don't recall that?
No, I'm sorry, I can't at all. I don't recall why. I have zero recollection of a lot of things, but zero recollection of this PwC report following it up or it being in train at all. I remember them being there and providing activities either for the Minister or department, but I don't recall specifically either following it up or asking where it was.
No further questions.
Ms Hogan-Doran?
No questions, thank you, Commissioner.
Ms Finlay?
No questions, Commissioner.
Right, thank
Mr
you.
Wood can be excused.
Yes, thanks, Mr Wood. You're excused. We'll adjourn till 10 o'clock tomorrow.
All rise. The Commission stands adjourned until 10 a.m. tomorrow morning.